participants. Hope everyone is
Morning.
doing good.
Good morning.
Good morning. Good morning. Am I audible enough?
You're audible, ma'am.
Okay. Okay. So today's session is disciplinary mechanism and the code of conduct. I hope everyone is with. I will say that everyone would agree to this point that whatever we are doing at every point of time, there is a concern whether we will get any, disciplinary notice in case if we miss out any of the things. Because at any point of time, anyone can complain against us, and therefore there is always a risk whether we are doing our duties in a very good fashion or not. So, since we are professionals, we have to abide by the law. We have to follow the code of conduct, and that is a very basic thing which we all understand, but the timelines are such that sometimes we fail, may not be intentionally, but it happens that we do not fulfill all the requirements as per the code of conduct. So there are some cases, there are some disciplinary cases which have happened earlier also, and that is what we are supposed to understand in this 3 hour of session. So I will not take you much into the theory part, that what is code of conduct, then what are the things in that. But yes, we will touch upon each and everything so that we quickly revise what is required. And for each category, if there is any specific thing which we have to keep in our mind, and there are some specific guidelines also which are time to time issued by IBBI and other IPAs also. So we will discuss that, as well as the disciplinary cases which have happened so far, be it at the level of IBBI or at the level of IPAs. So both the cases we will discuss so that we have a fair idea what is to be kept in mind while pursuing our assignments. So I'll quickly start with some questions which may come to your mind also. Let me just share my screen. So here I want all of you to be very, very active and reply. What do you feel in this case? So I'll be starting with a few FAQs so that we understand what is the scenario. Okay, so here goes the first question. Is holding a valid AFA really mandatory before giving consent?
Yes.
Have you all applied for the new AFA? It's already time.
Yes.
Yeah. And have you received the final new AFA? I mean, or it is still in pendency? Sometimes it happens that we have applied, but we have not received the approval for that. It may happen that way also. So whether meanwhile we are supposed to take the assignments or not, or whether we have the final AFA in our hand, then only we can accept the assignments. How the scenario is. Yeah, can anyone say?
We need to have the AFA before we can accept the assignment or give the consent.
So suppose the AFA is valid till 31st December. It has not been renewed further. Though we have applied, we have not received it. Can we accept the assignment during that time?
Yes,
Ideally,
ma'am.
no.
Yes.
Ideally,
Yes,
no.
ma'am. Yes.
Yes.
We can do so?
Yes.
Yes, ma'am.
Yeah, that is it. So we can do so. We can simultaneously submit that we have received the new AFA or renewed AFA later on also. But at the time of accepting, we must have a valid AFA. That is the mandatory requirement. So it is absolutely mandatory. The DC has repeatedly held that AFA is an eligibility condition, not a procedural formality. Giving consent or acting as an IRP or RP even for 1 day without AFA is treated as acting without authority of law. So basically, many disciplinary cases were there at the time when this concept was introduced. I mean, this AFA was taken up. So for that 1 or 2 years, there were a lot many cases for this AFA itself. Now I think the thing is more settled. The law is more settled. So here the DC's view is that consent date is irrelevant. Appointment or admission date actually matters. What is the best practice? Never issue consent unless AFA is valid on the expected date of admission. Next question. Can I accept a new assignment if a disciplinary matter or SCN, or that is show cause notice, is pending against me?
Yes, ma'am, we can accept.
We can accept the new assignment.
No,
Anyone?
we can't
No.
accept, ma'am.
We cannot accept. The reason being, sir?
The disciplinary proceeding is going on. That is dependency. That is not clear that what will be happen during that period.
So is it not sufficient that we disclose this to the
Yes,
client?
yes, that is going on. There is a column in giving the consent.
Yes.
I have a question. I have a question in question 1 itself regarding the validity of AFA.
Yes, sir.
AFA is valid for a year only. It
Yes,
keep
sir.
on like the cases goes on before admission. It took years to get actually admitted. So I think AFA should be valid on the day your appointment is being approved by the court, isn't it?
It is that only, sir. At the time of appointment, it is mentioned.
Well, we should have the valid AFA only at the time of appointment, not at the time of giving consent then. Because AFA should be valid when you are getting appointed. If it is not there, you cannot accept the assignment.
That is fine, sir. But again, being a best practice, you should have a valid AFA at the time of giving consent also, sir. Normally, we do have that, sir.
In cases I have seen, like people doesn't have the, when they have given consent, they do not have the valid AFA. But we have challenged this, and but we found that during on his appointment, he should have that valid AFA. That was the answer. So that is what I'm just trying to ask.
So if anyone is doing that, it should not be done that way. I mean, if you are giving consent, that means you are ready to take up the assignment. So it's better to have the AFA. That is what the best practice should be. So even if it has happened many a times that suppose when we make an application and we sometimes propose that we want this person as our IRP or RP or whatever. So in that case, if the NCLT finds out that this person does not have valid AFA, that person can be outrightly rejected. That will be the outright rejection in that case. So it's better to have AFA. That is the best practice, sir. Even at the time of consent also. That is my view. I mean.
Yeah, but it should actually, the AFA should be valid all the time.
Yeah, that, I mean, until unless you are caught, sir, I mean, that is something which we must think of. I mean, whether you want to do all the things at the last day or you want to be prepared much before that. So it is a person's, will, how he wants to handle the situation. So that is what, I mean, we are discussing these things just to make sure that no disciplinary action takes against us. So that is the thing. So,
Yeah, true.
okay.
Yeah, thank you.
So next question, can I accept
I have
a new
a pointer
assignment?
here.
Yes,
Murthy
sir.
here. I have a pointer here. Madam, at the time of giving a consent, my AFA is valid. But by the time I really got the assignment, the AFA expired and it's in the process. So,
Yes.
उस case में तो I can't take that assignment.
Yes, sir. Yes, sir. So again,
Similarly, at the time of applying for giving a consent, even it is in the process of getting renewed, I can go ahead and give the consent. Only thing is that appointment I can't take.
yes, sir. So what is the ultimate intention? We really want to get appointed, right? So it's better to have it in hand before doing or before accepting or before finally consenting to the assignments. So that is the best practice, sir.
Okay, madam.
At least we can say that we have applied, even though it has not been approved. At least we can say that we have applied and it is in the process of getting approved also. So that is something can always be put forth.
I believe there is no provision of deemed approval. Is there any time frame before which you must apply for renewal?
So normally people apply 1 month before they can do so, and even if see if it have expired, then also you can apply afresh. That is also okay. Since so, I'm just taking an example. Suppose I did not have any of the assignment in this year, so I thought, why to get it renewed? When I'll get an assignment, I'll get the AFA. That is also kind of thing people have in their mind. So it's not that we have to continuously renew it, but the best practice is if you really want to explore in this field, then you should have the AFA. That is what the case is.
Is there any time limit provided to the institute, the IPA, for renewing it once the
No,
approval,
sir.
once the
No,
application is
sir.
done?
No, sir. No, sir. There is no time limit, I guess. No.
Okay.
So how many of you follow up with the IPAs for getting the AFA?
I do.
So that is why, sir, they don't have any time limit. In fact, since we wanted, we have to follow up with them. So that is the thing, sir. Okay. So what is the answer for this one? Can I accept a new assignment if a disciplinary matter of show cause notice is pending? Some of you answered it.
I think somebody said yes, somebody said no, but I feel that if
Yeah, the answer is no, sir. Once the disciplinary proceedings are initiated, accepting fresh assignments is prohibited unless expressly permitted. So the idea is very, very clear here. Unless you are expressly allowed to take up the new assignments, you should not. So that kind of thing is mentioned already. So what is the DC view here? So pendency itself triggers restriction. Outcome is irrelevant. So we do not have to wait for the outcome. If already some proceedings are going on, you should not take up the new assignment. That is the view of DC. Then what is the best practice? You should always disclose that pendency is there, and it has to be disclosed in each and every of your communication, whatever you are. And decline the new work till the closure of this proceeding.
can we define disciplinary proceedings initiation? At what point it gets initiated?
Again, sir, what is it?
At what point? See, somebody may just put up a complaint against the IP. Is that the initiation of a disciplinary proceeding? After
No, sir,
receiving
just
this particular
no, sir.
complaint,
In that case, we have to understand the complete flow. Just by filing a complaint does not mean that action has been initiated by the disciplinary committee. So because proceedings will, the investigation will happen and the things will go on. And if you are issued a show cause notice, that will start of the proceedings.
okay.
That is
So
what
it is the issuing of the show cause notice
cause
which will
notice.
actually bar the IP from taking up an assignment.
Yes, until it is disposed of. That is what is mentioned here.
So I think the general rule that you are innocent until proven guilty
Yes, sir. Yes,
is
so
not
that
taken
is
care of by this particular point here.
yes, in this case, because I mean the disciplinary committee is of the view that firstly you should have a clean chit and then you should proceed further.
So it is
Even if
assuming
there
you
is
don't have a clean chit.
let it be. Okay, so let's go further. Next question. What if I did not know that a disciplinary matter was initiated? Does that happen? That a person is unaware that any disciplinary action is going on.
Unless the person is not looking at his emails to see that he has received a show cause notice, that should not be the case generally.
Yes, sir. But can that be taken as a plea of accepting new assignments?
I don't think so. I think IPs must be looking at their emails. They should be aware of what proceedings. And we are not talking about any email. We are talking about something coming from the disciplinary committee, which is a show cause notice. So it's an important correspondence. You must be aware of this.
Yes, you should not ignore if anything is coming from either IPA or disciplinary committee or IBBI, wherever. So if a person is ignorant, that will again be a kind of breach of code of conduct. So we are not responding to the important mails or the important communication which is required of you. So again, so the answer for this is ignorance will not be treated as a defense. IPs are expected to track their regulatory status proactively. And obviously they cannot accept any new assignment saying that they were ignored. Next question. Are disclosures a one-time requirement at appointment?
No, you have to keep on doing disclosures. That is not the thing. Everything
What is
has
the
to be done
frequency of disclosure, sir? What is the frequency?
For example, monthly disclosures of CIRP 5 has to be done. And with regard to any cases which you are handling in NCLT, it has to be applied. It has to be sent to IBBI and
Yes.
to IPA.
Yes.
All these things ought to be
Yeah.
taken up.
Yes.
It's not a one-time requirement. It is a continuous process.
Perfect, sir. Perfect. So normally we do update on the IPA portals. The reporting requirements are there. Monthly reporting is there from the side of IPs. So that is the crux of this question. I mean, the disclosure is not a one-time requirement. It is a regular phenomenon. So the answer here is no. Disclosures are continuous. Any changes in circumstances must be disclosed immediately.
Just a small point which I want to clarify.
Yes.
With regard to AFA, it is 45 days before your, your expiry of your, for making an application. You can make an application before 45 days.
Yeah.
Within 45 days, not before 45 days, within 45 days. And the IPA has got time limit of 90 days for resolving your issue of issuance of certificate, AFA certificate. There is a 90 days period they have been given to clarify on, there are certain questions which they ask. For example, your disclosures which you have made, there might be some technical mistakes committed or wrong information being informed or something like that. So normally they give you a chance to rectify those mistakes, and those time period is 90 days.
Okay. And so if one does not apply within 45 days, then is there anything mentioned regarding that also?
No, it is not mentioned like that. Actually, what happens is, 31st December 2025, everybody should have applied. If you don't apply, then there is an issue. Your AFA gets expired on 1st of January 2026.
Right, right. So if it expires, then also we can apply for fresh. I mean,
you can apply for fresh. You can apply for fresh at any point of time. It's not that you cannot apply.
Yeah, but the whatever you are saying, so that is the guidelines which are given that within 45 days you must apply. So that is something which we must keep in our mind. We should not act at the last moment. So that is the clear cut.
Normally, what happens is when you apply for an AFA, the questions are being asked by the IPA.
Yes, yes. Clarifications.
They send you clarifications are asked with regard to the cases. For example, in CIRP 5, you have filed something, there was irrelevant information or some not relevant information not being disclosed. You have to rectify that mistake by opening up that form, applying to IBBI and getting things done.
Right.
All these things play a vital role. And IPS don't check your, your mistakes or anything. They check it only at the time when you apply for AFA. That is the biggest problem which we face. Nobody gives you a heads up before the AFA is being applied.
Yes. So they do all the scrutiny at that point, that very crucial point of us. When we want
when your AFA is going to be expiring, when you are in need of an AFA, then at that time they ask so many questions.
Yes. And even if we do not have the proper record with us, what to reply, that creates a problem, because we also be very much, thorough with the documentation part, that whatever question is being asked, we must have the proper documentary evidence to show up. So that is also very important. Yeah.
That is very right, ma'am.
Yes.
So if I got it correctly, we cannot apply before 45 days.
No, you cannot apply before 45 days.
And the IPA may take up to 90 days. So there's a possibility
From
that
the date of
despite
your application, from your date of your application. For example, if you file it today,
Hmm.
for
3
example, it
months
is
from
20th,
there.
3 months from now, they have got time. 90 days time period is there for them to issue the AFA.
But again, sir, I think for IPAs also, it will not be mandatory to issue.
I probably see if your mistakes are too high and you are having other issues, for example, DC is there, not with your IBBI, even IPA का जो DCB है और आपका जो आप CA है तो उसका भी देख लेते हैं.
बिल्कुल बिल्कुल तो सभी तरफ से अगर कहीं
सभी
if
तरफ
there
से
is any
क्लियरेंस होना
problem,
चाहिए.
yes,
सभी तरीके से क्लियरेंस होना चाहिए.
okay. All right, so we are proceeding with this question. So what is the DC's view in this particular case? So outdated disclosure is as misleading as non-disclosure. Next, question number 5. If there is no actual conflict, can delayed disclosure be ignored? I repeat the question. If there is no actual conflict, then in that case, any delayed disclosure, if you have disclosed if you have disclosed late, whether it will be ignored.
If your
It is on the
disclosure
part
is
of IP.
Yeah, you have to pay a penalty for that. For example, CIRP 5, if you don't file it monthly by 10th, all forms have been made to 10th. Mandatory, it has become whatever forms are to be filed, for example, CIRP 1, 5, 2, 3, 4, 5, all to be filed by the next month of 10th for any actions of the previous month. This is
As per the
mandatory.
new as per the new guidelines, it is next month's 10th, by 10th you have to file it. So
For all forms, it has
for all
become,
forms, yes,
yeah.
yes.
Previously, there were different dates for different things when you do the action. Now it has been made to 10th. This is
Yes,
my opinion.
uniformity has been given in that case, in that regard, that everything has to be done by 10th of next month. But here, sir, besides these CIRP forms, suppose it is our, monetary, this is our monthly reporting or things like that. So it is on the part of IP disclosures, basically, if he's having any interest conflict or anything. Or
See, for example, at every point of time, you have to disclose whether you have any related party transactions with anybody for that matter. For example, with regard to, for example, if you appoint a valuer who is known to you, you have to
yes.
disclose it. It has to be approved by COC. All these things play a vital role. And if you don't disclose it, that means disciplinary proceedings can be initiated against you.
Yes. So again, the question is, if there is no actual conflict, people are okay with it. I mean, if I even have any
Say,
related party.
that is what I said, no? For example, if the disclosure, delayed disclosure does not involve penalty, you get your thing done. If there is a penalty to be paid, you are supposed to make the payment and then get it ratified. That is what is the thing.
Okay. So let us see quickly what's the answer. The answer here is, if we talk about the DC, it says that the answer is no. Delays will not be allowed. So DC focuses on the perception of independence and not just the actual conflict. So if you have any kind of related party disclosure, you have to disclose even if there is no actual conflict. So that is what is meant here. Timely disclosures are required. What is the key principle? Independence is judged ex ante and not retrospectively. That is the questions which we had, and now I'll be starting with the main presentation. Just allow me 1 minute to share the screen again. I hope you all can see my screen now. I'll just make it full screen. Just a second. Yeah, so here we are today discussing the disciplinary proceedings and the code of conduct for the IPs. So it obviously has two parts. What are the disciplinary proceedings? What have been the cases so far? We will be discussing that, and then we will discuss some part of the code of conduct, the theoretical part, and for each and every point, what are the do's and don'ts specifically. So that is how we will discuss the whole thing. So if we talk about the disciplinary committee, how does it see the whole thing? So from their point of view, they judge it in this fashion: can this particular IP be trusted as a neutral fiduciary? The concept or the mindset of DC is like that. So if they consider someone trustworthy, the criteria is proper documentation should be there, proper conduct should be there, discipline should be reflected. He must be able to create trust among the public, and that is what a trustworthy IPA would mean in the eyes of DC. In their, on the other hand, I would say untrustworthy IP would be a person who lacks support, or there are cases of indiscipline, maybe with respect to disclosures, or filing reports in a delayed way. So if a person is continuously delaying something, that is creating untrust, or it is not considered as trustworthy insolvency professional in the eyes of this DC. So even if you are doing it without any intent, that is irrelevant for them. So procedural faults, if any, are done, even if you can say that this was not done with any malified intention or something, still DC will hold the view that since there are so many lapses on your part, then you have not been able to follow the code of conduct, so you will be held guilty. So that is the whole take from the DC side. Let us assume a scenario. There's an insolvency professional, Mr. X, who was appointed as RP for Ruchi Agro Limited. During the CIRP, he appointed a valuation firm that previously worked with his own CA firm without disclosure to the COC. So what is the issue involved here? As we can clearly make out, there is a conflict of interest and lack of independence in the appointment of the IP. So what is the outcome in this? This is a real case. It's a Ruchi Soya case. So what was the outcome? NCLT viewed that the appointment was compromised. The RP's integrity and impartiality were questioned here. So the takeaway for all of us is transparency and pre-appointment conflict checks are not negotiable. Ethics is not optional, but it is procedural. So you have to follow what is supposed to be done. So everything is in a procedural way, you have to do it. Next. The RP accepted claim amounts and valuations submitted by one party without cross-verification or counter-checking the fairness of the estimates. So what has happened here? RP has accepted the claim amounts and also the valuation submitted by one party without cross-verifying or cross-checking the fairness of those estimates which were submitted. The issue is failure of due diligence, compromising the fairness. And this is again a real case of Divan Housing Finance Corporation Limited. Here the RP, the issue here ultimately the RP was ordered to re-evaluate the claims and disciplinary action was initiated. Due care is not just procedural, it's part of professional integrity. That is the takeaway for all of us. Next. In one COC meeting, the RP's team manipulated minutes to reflect a consensus that did not exist. So just to speed up the process, the RP team, what it did was they prepared the minutes in such a way showing that everyone consented to that particular resolution or whatever. However, it was not the actual picture. The issue is misrepresentation and professional misconduct. And this is again a real case of IL&FS transportation networks. Here, RP was suspended by IBBI. Ethical behavior, so takeaway for all of us is ethical behavior includes accurate documentation as well, and not just compliance checklist. So we have done this, we have done that. If we just tick mark like that, and if we do not keep a proper documentation, or if we do false documentation, that will also amount to ethical issues. So that will also bring the disciplinary actions against us. So what are the factors which are seen during the insolvency process evaluation? So evaluation here would mean how the disciplinary mechanism sees, or how does it evaluate your entire assignment. So what is the overall impact on the process? That means what is the ultimate effect on the insolvency proceedings, whether you are able to justify, or whether you are able to bring a win-win situation for all. Next is the intent. What is the purpose behind the actions? If we talk about any particular IP, then what was the action behind a particular action which he has taken? What was the purpose behind that particular action? Why he did such thing in such way? Next, if anything is happening repeatedly, so what is the frequency of the similar breaches? That is what the DC sees here. And then what is the gravity? Whether that breach is serious enough to cause loss or untrust in the society, or like that. So these could be the scenarios which the DC basically checks while pronouncing any of the orders. So before going further, let us quickly understand the basics, like what are the various provisions as per the code in this whole disciplinary mechanism. What is the code of conduct? So I'll just share the Word file. Just give me 1 minute. So any idea what all sections are relevant to be read in this scenario? I hope this is visible. Okay, so let us understand from where do IBBI gets the power, or disciplinary committee, or IPAs, they get the power to take action against the insolvency professional. So let us start with section 208. It says functions and obligations of insolvency professionals. So this is the primary charging section for the IP misconduct. So I'm not taking the exact detail which is mentioned, but the key statutory duties which are mentioned here are that IP must act with reasonable care and diligence. He must comply with the code, rules and regulations, bylaws of the IPA, and he has to abide by the code of conduct. IP should also take reasonable steps to avoid conflict of interest and disclose any material interest. So practically most disciplinary cases are framed as violation of section 208, subsection 2, clause A to E. So this is the particular section which is clearly mentioned in any of the show cause notices, that the breach has happened in this section. Next section which is relevant for us to understand is section 217. It is basically the grievance redressal section. This is the section under which any person can file complaint. So any person who's aggrieved by the conduct of the IP or by the conduct of the IPA, they may file a complaint before the Insolvency and Bankruptcy Board of India, that is IBBI. So complaint can be filed under section 217 by any person. Even against IPA, you can file a complaint. So the complaint will go to IBBI, and then the proceedings will start. So IBBI will start the investigation and all, and then if they find something concrete, they will pass it on to the disciplinary committee to take further action. Next section is 220, power of IBBI to inspect and investigate. So IBBI may conduct inspection, or it may order investigation. So what is the difference between these two, inspection and investigation? Anyone? Is there any difference between inspection and investigation?
Yes, first on the basis of inspection is that what is the document? So just looking into that, what the
Yeah.
conduct. And
Okay.
investigation after that, whether there is a violation or not of code of
Exactly.
conduct.
Exactly. So it's a normal checking. Inspection is just a normal checking. There is no preconceived notion that any fraud has taken place or any misconduct has taken place. It is a normal inspection, normal checking. I mean, in your day-to-day routine activity, also, IBBI may ask some documents to check or inspect on its own. So that can happen. That is a normal inspection. So IBBI has the authority to inspect your documents or your assignment details. So that is the power with them. If anyone complains, then it may lead to investigation. Maybe suo moto also, IBBI can go for investigation wherein they have a belief that something wrong has happened. So investigation is a thorough checking. So inspection may not be in that in depth, but investigation is a thorough checking. Everything is checked in detail. So that is the power with the IBBI. They also have the power to appoint investigating authority. So what are the trigger points for investigation and all? So trigger point could be if anyone has filed any complaint, if they have received any information from court or NCLT, from any media reports, if they are getting anything, then if any supervisory inputs they have received from IPA. So if IPA is also of the view that a particular IP has not performed diligently, they may complain to the IBBI, and then IBBI can further investigate. Or as I have already said, suo moto action can also be taken by IBBI. Next sections are section 220 subsection 3 and 220 subsection 4. These are related to directions and penalties. So what can happen after this investigation and all takes place? So IBBI may issue directions, it may impose penalty, or it may initiate the disciplinary proceedings. So all the three possibilities are there. So maybe in the investigation, whatever it has seen, it may issue direction on its own, that IP is directed to do so and so, or it may impose penalty, or it may either ask the disciplinary committee to start or initiate the proceedings. That can also happen. Next, regulatory framework governing the conduct and discipline. So here we are seeing the regulation 7, basically the regulation 7 of IBBI Insolvency Professionals Regulations 2016. So basically the code of conduct which we will be seeing here. So regulation 7 is specifically for the certificate of registration. This registration is conditional and it is subject to ongoing compliance, fitness and propriety, and code of conduct. Regulation 11 talks about transitional or ongoing obligations. Here IP remains bound by the code even when not handling assignment. And this is very, very important. I'm just mentioning it again. IP remains bound by the code even when not handling any assignment. Suppose I have already finished the assignment, the resolution has taken place, and still I have to abide by the code of conduct. I cannot, reveal the confidential information to anyone, or any kind of things which are mentioned in the code of conduct. So whether I am on the assignment or whether I am not doing the particular assignment, because sometimes replacements also happen. So if an RP has been replaced by some other RP, in that case again you have to you have to follow this code of conduct. You cannot say that I am not handling that particular assignment, so I am not bound by it. You are still bound by the assignment, the code of conduct in that regard. Regulation 12 deals with the code of conduct. Schedule 1 to the regulations, it clearly says that it applies at all times. It applies at all times. Next, it applies assignment wise and again behavior wise. The key principles, we all know that it relates to integrity, objectivity, independence, professional competence, confidentiality, fairness to the stakeholders, etc., etc. We will discuss each of them in detail, a little bit detail. We will talk about it and what are the do's and don'ts. We will also discuss that. Next, IBBI Inspection and Investigation Regulations 2017. These regulations govern how inspections are conducted, how investigation reports are prepared, and what the procedural fairness overall, how it is to be maintained. That is given in these regulations. Next is IBBI Disciplinary Proceedings Regulations 2017. This regulation set or it lays down the issue of show cause notice, how the show cause notice can be issued, on what could be the grounds and all. Opportunity of being heard, which should be given. It is all mentioned. These are the proceedings, how the proceedings should go. That is what is mentioned in these regulations. What is the role of disciplinary committee? What can be the nature of penalties? Everything is mentioned in these regulations. Now, if we talk about the various institutional authorities, then in that case, let us first understand what does the IPA has, what powers does this IPA have? So, insolvency professional agencies like ICSI, IIP, or triple IPI or ICI, IPA, in that case, what do they have? What powers do they have? So, firstly, they have a frontline regulator because basic information comes to them. They can also scrutinize and then they can form an opinion that something is not something is fishy, or maybe they can file a complaint to IBBI. So they are considered as the frontline regulator. First layer of supervision is obviously with them. Next, if we talk about the powers of IPA, then their power includes monitoring the professional conduct. So time to time, they may issue guidelines how you should do a particular thing in a particular way. Maybe some IPAs regularly issue guidelines. Then you may also ask them whenever you have any doubts how to deal in a particular situation. You may also consult them. They will again guide you in that way. So monitoring can be done off and on by IPAs. They can issue advisories, they can issue warnings, they can issue caution that is under their control or their domain. They can also conduct limited disciplinary actions under its bylaws. So disciplinary action can be taken by themselves also. So that is given here under their bylaws. They can also take some or the other action against IPs. Then next, they can refer serious matters to IBBI. So if something can be handled by them at their at that stage itself, they will handle it at their own. But if they think something serious is there or further investigation is required, they may send it to IBBI to take further action. So IPA action does not bar parallel or subsequent IBBI action. So parallelly, both the institutes can take action. So this is the meaning. Next, if we talk about IBBI, the core powers are registration, suspension, or cancellation of IPs. Inspection and investigation can be conducted by IBBI. We have just seen that. Issuance of show cause notice, placing the matters before disciplinary committee. That is their power. Next, IBBI act as a regulator, prosecutor, and secretariat to the disciplinary committee. Now let's talk about the disciplinary committee itself. It is constituted under section 220 and it conducts the disciplinary proceedings as per the regulations. What is the nature of disciplinary committee? It's basically a quasi-judicial body, independent of investigation wing. So it has its own proceedings. What are the powers of DC? They may impose penalties. They may suspend the registration. They may cancel the registration. They may debar IP for specific period. They may issue the directions, impose cost, etc. If we talk about the flow chart, how it all goes in event by event or point to point, how does it flows overall? So first of all, the trigger point is any complaint which is made under section 217. So complaint can be made by any person against either IP or IPA. So if there is any complaint, that is the triggering point. So with the triggering point could be the information from the NCLT or NCLAT or any IPA reference or suo motu by IBBI. So if any of this is there, that will be the starting point of this disciplinary action. When they have this kind of triggering point or any complaint or anything like that, then inspection or investigation starts. So it is ordered under section 220. IP is called for records or explanation. Then investigation report is prepared based on the explanation or the documents submitted. In that case, IBBI forms a prima facie view on the basis of the records, on the basis of the documents which they have received or whatever the investigation officer has revealed. So on the basis of all that, prima facie report is prepared. And there itself, it may have the decision to issue the show cause notice. So only after the investigation, the show cause notice is issued. Next, show cause notice. If this is the stage 4, when show cause notice is issued, it will have the details like the facts, what are the violations which they think you have made, or what are the provisions which are breached. So for all these, you have to reply. Any person who's guilty or to whomsoever the show cause notice is issued, they have to reply. And a proper time is also mentioned within which you have to submit your written reply. So time is granted for written reply. Stage 5 will be the reply by the IP. So when any show cause notice is received by the IP, he has to rebut, he has to put his things on record. So any facts which he wants to convey has to be put there in writing. He has to submit everything in the legal, as per the legal provisions also, wherever he finds that he has done it in the legal manner. So he has to convey that also, and he has to produce each and every evidence and the documents supporting his deeds. Next, he will also be given a time for personal hearing. So before disciplinary committee, oral submissions are done or any clarification is sought, that is in the form of personal hearing. Next, finally, we have the disciplinary committee order. So this will be a reasoned order. Obviously, the reasons will be there. Findings on each charge. So for each charge, suppose there are 3-4 charges in the same show cause notice, then for each and every charge, you will find proper reasoning for that, proper facts for that, why it has led to that specific order, that everything findings will be there. Then penalty or the direction. Finally, for each charge or consolidatedly, they will mention the penalty or what is the further course of action. That will be mentioned in the DC order. So the DC order is a very detailed order wherein the reasons are mentioned, the findings are mentioned, and ultimate outcome, that is whether penalty is imposed or what is the ultimate direction, whether suspension is asked or whatever. So this is mentioned in the DC order. Next is the publication. Orders are uploaded on IBBI website. Public domain disclosure is also there, and it is binding precedent. It will have a binding precedent value. That means you have to abide by it. What is the typical nature of violations observed? So what are the various kinds of violations which are observed by the DC? So these are the various things under section 208 and the code of conduct. Both of these are found. People are breaching these. So lack of independence is shown at many times. Conflict of interest, delegation without any proper supervision, mechanical approval of claims, delay in statutory timelines, inadequate record keeping, acting beyond authority of COC or the code, non-disclosure of relationships, fees irregularity. All these could be the reasons for which the show cause notice can be issued. Regarding penalties, what DC can impose. So DC may issue warning or caution. That will be a lenient approach. Then they may also suspend the registration. They can also cancel the registration permanently. They may either bar the IPs from further taking up further assignments. They may impose the monetary penalty also. They can impose cost and may also direct corrective measures. So DC looks at the gravity, repetition, intent, impact on the process, and not merely the technical breach. So this is how the final decision is given by the DC. They look at the gravity, whether it is a repeated case, what is the ultimate intention. So normally we have an impression that they are being very harsh, but it is not so. If we have proper evidences, if we have proper supportings, uh, it's not that they are always to punish us. They are also lenient in their approach, but it should be produced in front of them that these, suppose if any kind of repetition has happened, there should be a reason for that. So you have to be very cautious enough to provide the reasons, or you should have proper documentation for each and everything to just have a easy escape in that regard. So what is the practical takeaway for all of us in this case? Section 208 is read holistically and not in isolation. So you must understand this section 208 completely, because most of the breaches are happening in this section 208 if we are not thorough with it. No malified intent is not a complete defense. So if even if IP says that some breach has happened, but it was not done with a malified intention, or it was not done intentionally whatsoever, if any lapse has if there is any lapses, or if there are any breaches, in that case it cannot be a complete defense. It will not be, because there are irregularities. So DC is basically getting your irregularities, or it is actually checking your irregularities. It is not checking your intention. Next is documentation and disclosures are the first line of defense. So if you really want to get an easy escape, you should have the documentation and disclosures properly ready with you. Then IPA advisory is not immunity from IBBI action. So if you just say that we have taken guidance from IPA and there how we proceeded, it may not be an immunity for any kind of IBBI action. So this is also clearly mentioned here. In few of the cases it was there. Then DC orders reflect process integrity over commercial outcomes. So they properly check your integrity. Overall, how was the process? So that is how they take the action here. All right. So I will just take up the code of conduct part, and then we will take up some cases. Or what we can do is we can take up some cases first, so that it will not be a very theoretical session, and then later on we can, after a break, we can have a code of conduct part. That way also we can do. So some cases, some disciplinary cases by ICSI IIP, that is something we will take. So let me just open that file and then I'll share. Just a second. Yeah, just let me know if the file is visible to all of you. I think now you can see.
Yes, we can see.
Okay. So again, since the inception, there are so many cases. So the initial cases were with respect to setting up the procedure. If you are not able to do the things in a right way, then IPA was taking action. Later on, the actions were taken on some different thing altogether. So again, you will see that in 2019 to 20, whatever orders were there, they were on a separate issue. Then if we see the orders of 2024 or 25, they will be on a separate issue. So let us quickly see these cases. So the first case is of Ma'am Mamta Benani. This is a very landmark case, I would say. Let us understand the backgrounds of this case. I think ma'am is already there in the session. Ma'am, are you there? I could see your name. Okay, let it be. Ms. Mamta Benani was acting as an insolvency professional in a CIRP. Complaints were received alleging that the IP had failed to maintain independence and objectivity. There were serious concerns regarding preferential treatment of certain stakeholders. The IP's conduct suggested that she was acting more as a stakeholder aligned professional rather than a neutral process fiduciary. The matter was examined by ICSI IIP as one of the first serious tests of how independence and fiduciary responsibility of IPs should be enforced under the IBC framework. So sometimes we also get emotional with the COC and we do things like that. So again, it is said that you have to be professional. You cannot mix your roles. So that kind of thing has happened in this case. So what was the issue involved? What is the nature of the role of an insolvency professional under the IBC? So regarding the nature of the role of IP that is being discussed in this case, whether an IP can justify conduct by claiming commercial expediency or stakeholder pressure, whether perceived bias, even without proven financial loss, amounts to misconduct. So even if there is no loss as such, still it can amount to misconduct. This was decided in this case. So let us see what were the violations which were alleged here. Breach of Regulation 7 of IP regulations, violation of Code of Conduct requiring independence, objectivity, fair treatment of stakeholders, failure to act as a fiduciary of the insolvency process. What were the arguments given by the IP here? The IP argued that decisions were taken in the commercial context of CIRP. No stakeholder had suffered quantifiable financial loss. Actions were taken in good faith to keep the process moving. The IBC is a time-bound legislation and practical decisions are inevitable. What were the arguments of ICSI, IIP in this case? They took principle-based position arguing that the IP is not a representative of any stakeholder. The IP's primary obligation is to the process and the statute. Even the appearance of bias undermines the credibility of CIRP. Loss or gain is irrelevant in judging the professional misconduct. What were the findings and reasoning in this case? The disciplinary committee made several foundational observations. An insolvency professional is a fiduciary of the process and not an agent of the creditors or management. So this was the final take here, that the insolvency professional is a fiduciary of the process and not an agent of the creditors or the management. Independence is not judged only by the outcome, by their conduct and perception. IPs must demonstrate detachment from stakeholders' influence. The insolvency regime cannot survive if IPs are seen as partisan actors. The committee clearly held that commercial expediency cannot override statutory ethics. So what was the final conclusion or the directions? The IP was found guilty of professional misconduct. Appropriate disciplinary directions were issued, including adverse findings affecting professional standing. What is the takeaway for all of us? This case defined the role of IPs in India. IPs are process fiduciaries, not deal facilitators. No loss caused is not a defense. So if you are taking this plea that actually there was no loss, whatever actions I have taken, There is no loss as such, but still it cannot be taken as a defense. Even perceived lack of independence can attract disciplinary action. So this case is the bedrock on which later conflict of interest jurisprudence stands. Next case. Bhavna Ruiya, she is also an insolvency professional, and this is a case belonging to this particular year 2019-20. What is the background of this case? Ms. Bhavna Ruiya, an insolvency professional, faced proceedings for non-compliance with disclosure and reporting obligations. The allegations broadly related to incomplete disclosure regarding assignments, failure to keep the IP informed of material developments, lapses in procedural transparency expected from an IP. This case arose when the regulatory framework was still evolving. So we see the time duration, it was between 2019 to 20. So at that time, this particular case happened, and it tested how strictly disclosure norms would be enforced. What were the issues involved? Whether disclosure obligations are technical or substantial, whether inadvertent or minor lapses can be condoned, whether intent is relevant in professional discipline. So what were the violations alleged? The first one, that breach of disclosure requirement under IP regulations. Second, violation of the code of conduct relating to transparency, professional diligence, etc. What were the arguments given by the IP in this regard? The IP contended that lapses were procedural and not intentional. There was no attempt to mislead regulators. The insolvency framework was new and evolving. Corrections were made once issues were pointed out. So even if there were some issues, later on the corrections were done. So that was also an argument given by the IP here. And obviously, she mentioned that since the law is evolving, everything is not clear. So it might happen that something could be missed or some kind of lapses could happen. What were the arguments given by ICSI IIP here? First, disclosure norms are foundational and not optional. The credibility of the insolvency ecosystem depends on accurate reporting. Next, professional discipline does not require proof of intent. Evolution of law does not excuse non-compliance. So they have clearly mentioned evolution of law does not excuse non-compliance. Next, what were the final findings and the reasoning? The committee held that disclosure and disclosure obligations operate on a strict compliance basis. IPs are expected to err on the side of over disclosure. Even unintentional lapses erode regulatory confidence. Professional standards cannot be diluted due to infancy of law. So what was the final conclusion here? The IP was held to have breached professional obligations and appropriate directions were issued in this regard. So what is the final takeaway for all of us? Disclosure is a continuous and strict obligation. New law or learning phase is not a defense. Accuracy and completeness are expected at all times. So whatever it is, we have to be on toes. We have to, complete everything on time. We have to be doing every kind of disclosure on our part. That is what is required. At least have the proper documentation at all times, just to safeguard. Next case. It is regarding the early membership conduct orders. The background of this case is these involve this membership eligibility issues, incomplete documentation, non-compliance with IPA directions, failure to meet professional standards. So though factually they look simpler, they were important in establishing the disciplinary culture. So that is the thing which is there, the idea which is given by ICSI IIP. So what were the key findings across these orders? IP registration is not a privilege. It is a privilege. In fact, it is not a right. Compliance with IP directions is mandatory. Professional standards apply from day one itself. Lack of experience is not an excuse. Again, you cannot say that I did not have any experience in this field or whatever. So regarding this 2019 to 2020 phase, fiduciary theory of IPs were firmly established. Disclosure and independence were treated as non-negotiable. Disciplinary proceedings focus on system credibility, not individual hardship, and intent and loss are largely irrelevant. So if you just see these cases, what is it doing? The role of IP, it is justifying that while framing the overall code, we are saying that there are 4 pillars to it. One is IP. IP is doing his or her part. Then what is the role of IPA? They have to monitor the working of IPs. So for that purpose, whatever there is in the code, the IPA is again, playing a very vital role in um, managing everything, that whether IPs are conducting the things fairly, or is there any lapse on their part, so that overall procedures are set. And also there is a some kind of fear in the minds of IP that if we do not follow something, then IP will take hold of us. So that kind of scenario was built during these years. Next phase is we will be discussing the case laws for 2021. Here, ICSI, IIP, they moved from principle setting approach to the enforcement approach. So here, their tone has clearly shifted, and it is basically related to the compliance discipline matters. So the case is regarding Jitesh Gupta, insolvency professional, and the date of order is 4th May 2021. What are the background or the facts of this case? Mr. Jitesh Gupta, an insolvency professional, was earlier subjected to disciplinary action by the disciplinary committee of ICSI IIP for alleged professional lapses in the conduct of his assignment. Aggrieved by the findings and penalty imposed, the IP preferred an appeal before the appellate authority of ICSI IIP. So IP had preferred an appeal before appellate authority of ICSI IIP. So here, if you can make out, then that you can even go for appeal. So if the IP is not satisfied with the order of IPA, then appellate authority is also available for you. So you can always go for filing the appeal. So appellate authority is also there. The appeal primarily questioned the correctness of the factual findings, the proportionality of disciplinary action, the scope of powers of disciplinary committee. What were the issues involved here? What is the scope of the appellate review? What is the scope of the appellate review in the disciplinary proceedings? Can the appellate authority reappreciate evidence like a court of first instance? So basically, in this case, we will understand what is the overall power and authority of this appellate body. Whether can disciplinary findings be interfered with? What were the arguments given by IP, who's the appellant here? The IP argued that the disciplinary committee had incorrectly appreciated facts. Certain findings were based on assumptions rather than evidence. The penalty imposed was excessive. Minor procedural lapses were exaggerated to misconduct. Arguments given by the respondent here. Disciplinary proceedings are fact intensive, so proper facts are there, so they can justify in that regard. The disciplinary committee is the primary fact finding authority. Appellate interference is limited to cases of perversity or violation of natural justice. This is what they argued in this particular case, that appellate interference is only limited, and it is limited to the cases which are violating natural justice or any case of perversity. Professional discipline cannot be diluted by re-arguing the facts. So again, they are saying that once the order is issued, it cannot go for appeal or something. So you cannot argue again on the facts. So what was the final finding and reasoning in this particular case? The appellate authority held that it is not a court of rehearing. It will not substitute its own factual conclusions merely because another view is possible. Interference is justified only if findings are perverse or principles of natural justice are violated. So same thing which it has held the arguments of ICSI, IIP valid here. The authority emphasized that professional disciplinary system require finality. So ultimately, final output should be there. We cannot go on appealing against it again and again. That is what the final outcome. The conclusion was the appeal was dismissed. The disciplinary findings and directions were upheld. What is the takeaway for the professionals in this regard? Disciplinary findings carry high finality. Appeals are not second chances on facts. Most defenses must succeed before the disciplinary committee itself. Procedural discipline is not minor in regulatory law. So ultimately, if you want to go for appeal, you should have a proper valid ground that some natural justice has been hampered or something like that. So each and everything cannot go for appeal. That is what the clear-cut issue here. Next case is regarding Mahesh Venkatraman sir and Rajendran Shanmugam. Okay, so these are the common orders. What is the fact of this particular case? This was a combined order involving two insolvency professionals, both facing allegations of multiple compliance failures during insolvency assignments. The allegations included failure to comply with statutory timelines, inadequate documentation of decisions, poor maintenance of records, non-adherence to reporting obligations. Importantly, these were not isolated lapses, but repeated deficiencies were noticed across the assignments. So what was the issue involved here? Whether repeated procedural lapses amount to serious misconduct, whether cumulative negligence can aggravate the liability, whether absence of nullified intent mitigates responsibility. What were the arguments of the IP in this regard? The IP submitted that lapses were technical and unintentional. No stakeholder suffered any kind of financial loss. The insolvency process is complex and time-bound. Errors should be viewed leniently when there is no bad faith. What were the arguments given by the IP in this regard? Repetition converts negligence into systematic failure. So this is a very big statement. Repetition converts negligence into systematic failure. IPs are expected to have robust compliance system. Professional discipline is preventive and not compensatory. No loss is irrelevant when the process itself is compromised. So again, this last point is also very relevant, that even if there is no loss, if the process itself is compromised, it will not be acceptable. So that is the approach, the argument which has been taken by the IPA here. So what are the final findings and the reasoning? The disciplinary committee held that an IP may be excused for an isolated lapse, but not for a pattern. Repeated non-compliance reflects lack of professional diligence. IPs cannot plead work overload or complexity as a justification. So even if you are giving this kind of justification, that this will not be acceptable, that you are overloaded with the work or the assignment was very much complicated, something like that. The insolvency ecosystem depends on process predictability. What was the final conclusion or the penalty provision in it? The IPs were found guilty of professional misconduct. Disciplinary directions were issued taking into account the cumulative nature of lapses. What is the final takeaway for all of us? Multiple small lapses together become serious misconduct. Compliance system must be institutional and not ad hoc. Repetition is an aggravating factor. And lastly, professional discipline focuses on process robustness. So if the process is going smoothly, everything is good, then in that case, you will not find any kind of disciplinary action. Are we okay to go for the next case? We can take a break after 10 minutes. Within 10 minutes, we will finish up a few cases. Is that okay?
Yes, it's okay.
Okay.
Yes, that
Thank
will
you.
be fine.
Thank you. Thank you. Okay, the next case is Ashok Kumar Verma. This is a case of, again, 2021 disciplinary orders we are seeing. Mr. Ashok Kumar Verma was proceeded against for failure to comply with the directions of ICSI IIP, and deficiency in furnishing information sought during regulatory oversight. So again, if you are ignoring the mails from your IPA, it can bring, disciplinary action. So this is the case. The IP did not deny non-compliance, but contended that the lapses were administrative. There was no deliberate defiance. What was the issue involved? Whether failure to follow IPA direction constitutes misconduct, irrespective of the intent. So the arguments given by IP was like there was no non-compliance was inadvertent. Eventually, information was provided. So yeah, in the beginning, I did not reply to you, but later on, I provided the information. That kind of argument was given by the IP. What did ICSI IIP said here? What the arguments given by them? IPA directions are binding. Delayed or reluctant compliance defeats the regulatory supervision. What is the finding and conclusion in this regard? The committee held that compliance with IPA directions is mandatory. IPs cannot unilaterally decide priority of regulatory instructions. So it is not the IPs who have to decide the priority. So that this is what is final conclusion here. Delayed compliance itself is a misconduct. So if compliance is delayed, then also it amounts to misconduct. What is the final takeaway? IPA directions have statutory force. Regulatory compliance is not optional or secondary. You have to abide by it. So ultimately, if we see the overall cases of 2021, it was established that appeals are narrow. Factual findings were rarely distributed. Cumulative negligence aggravates the liability. Compliance failures are treated as governance failure. Intent and absence of loss have limited relevance. IPs are expected to operate institutional grade systems. Now let us move further to 2022 orders. Okay, so here again, if we see this phase is crucial because ICSI IIP moves from compliance expectation to accountability enforcement. So much more, it is becoming more and more strict. So from the entrance point till here, I mean the shift we are seeing, we are able to see that now they are focusing more on accountability enforcement in this year 2022 orders. We will see that. So let us see. This is the first case, Rajkumar Mehta. The background of the case, this order concerned two insolvency professionals who were proceeded against for deficiencies in conduct of insolvency assignments, particularly relating to inadequate supervision of CIRP activities, failure to ensure correctness and completeness of statutory filings, over-reliance on staff or external professionals without demonstrable oversight. So this point also we all must be very vigilant of, that you are over-relying on your staff or any external professionals like valuers or any transaction auditors or anyone. So if you are relying on just their reports, then again it may fall further disciplinary action. So during inspection, it emerged that several filings contained inaccuracies. The IPs could not explain or justify certain procedural decisions. Responsibility was frequently attributed to team members or consultant. So you cannot just shrug off your liability saying that this report was not filed by me, or this particular form was not filed by me, or it was done by my junior team member or something like that. You cannot say that. What are the issues involved? Whether an IP can escape liability by attributing lapses to staff or advisors. Second, whether lack of personal involvement in routine compliances is acceptable. Next, what constitutes due diligence under the IP Code of Conduct? The violations alleged here were breach of Regulation 7 of IP regulations, violation of the Code of Conduct relating to due diligence, professional competence, responsibility, and accountability. What are the arguments given by the IP in this regard? The IP argued that insolvency processes involve voluminous documentation. it is commercially impractical for the IPs to personally verify each and every detail, which we all can think of. So errors were inadvertent and clerical. No stakeholder prejudice was demonstrated. So ultimately, he is justifying that since the work is so much and it is, a humongous responsibility, I cannot see each and everything. So something is being done by the junior staff, and there's no much loss to the parties. There's no prejudice to anyone. And the errors are also very clerical or, very minuscule. What was the argument given by ICSI IIP in this regard? They countered, saying that IPs are expected to establish systems of control and supervision. Delegation does not dilute the responsibility. Clerical error is not a blanket defense. The insolvency framework relies on accuracy and reliability of filings. What was the finding and the reasoning given by the DC here? An IP cannot function as a mere signatory or figurehead. Delegation without any kind of supervision amounts to abdication of duty. Due diligence requires application of independent professional judgment. Repeated inaccuracies indicate systematic weakness, not isolated error. What was the final conclusion in this regard? Both IPs were found guilty of professional misconduct. Disciplinary directions were issued to reinforce accountability standards. What is the final takeaway for all of us? Okay, so if we say that my team did it, it was not me, so it is not a good defense. IPs must demonstrate active supervision. Systems and checks are as important as expertise. So again, you have to build in systems. Nowadays, you can take help of AI and you can build some systems for yourself. Obviously, the scenario has changed much after this 2022 case, obviously. The things are more streamlined, but still, there is a requirement of having proper checks and balances in our offices. Next case is
I have a
regarding.
question here actually.
Yes, ma'am.
I don't remember the section exactly, but I think under the IBC code it says somewhere that any document on filed before the NCLT AA should also file before the IPA. But the kind of litigations going on in some of the cases, there are so many IA rejoinders. So is IP expected to file every reply they are filing there with the IPA? It would be very difficult, and I don't know what is the mechanism with IPA to submit such information. There are many IAs getting filed. We are replying also to those IAs. Rejoinder goes, and it is endless actually. In every case, there are multiple IAs. So I think, is there any definition category? What kind of document are required to be submitted with the all document is a very vague statement actually, all includes everything. So it's difficult for us even sometimes to decide what need to be submitted with the IPA, what not, and how to submit it through emails only, or what is the way to submit it? If you can just give your views on this.
Ma'am, again, as you know, obviously this kind of issues are raised again and again at various forums. So maybe in the new code, which we will be having, the amended code which we are having, there might be some relaxation in that. We will see what when it comes actually. But as of now, whatever you are saying is correct. There is no proper demarking what is to be submitted to whom. It's all documents to be submitted, because both are considered as different parties. So you have to submit to both of them, to all of them, I mean, whomsoever. If anyone has any other view, please, you are open to share your views also. Anyone from the audience? Okay. Can we take up this one more case here?
Yes, please.
Again of 2022. Yeah. So this order covered 3 insolvency professionals. The name are reflected here, Vijay, Kumar, Sharma, and all. So I will not take the names. I'll just go to the details directly. This order covered 3 insolvency professionals involved in different assignments, but facing similar types of misconduct, namely procedural lapses in CIRP and liquidation processes, inadequate record keeping, failure to strictly adhere to the statutory timelines, and insufficient documentation of decisions taken. In each case, inspections revealed gaps in process discipline rather than isolated mistakes. So, what was the issue involved? Whether procedural compliance can be relaxed in practical insolvency situation. Next issue was whether delay and poor documentation constitute a misconduct. Third, whether IPs can rely on commercial uh, practicality as justification. So, what were the violations which were alleged in this particular case? Breach of multiple provisions of IBC and regulations. Next, violation of code of conduct concerning diligence, timeliness, and transparency. What was the argument given by the IP in this regard? IP contended that insolvency proceedings involve multiple stakeholders and dependencies. Delays were beyond their control. No nullified intent existed. Ultimately, the process objectives were achieved. Arguments given by ICSI IIP, they argued that IBC is a time-bound statute by design. Documentation and timelines are not optional. The IP is responsible for driving the process proactively. Practical difficulties do not override statutory mandates. But obviously, I think many time it happens that we cannot abide by the timelines. But again, you have to have some document to prove that you tried from your side, but it was not lapse on your part. So that is what I think the takeaway should be. Let us understand the findings first. The committee held that the IP's role is to manage and control the process, not merely respond to the events. Timelines under IBC are to be strictly observed unless lawfully extended. Poor documentation undermines transparency and accountability. Completion of CIRP does not cure procedural violations. What was the final conclusion here? All three IPs were found to have committed professional misconduct. Penalties and corrective directions were imposed on proportionate to the lapses. What is the final takeaway for all of us? Process completion does not absolve procedural misconduct. So even if you say that ultimately the procedure or the process has come to a satisfactory conclusion, still if there are some procedural lapses, it will tend to amount to misconduct. Timelines are recorded. Timelines and records are core governance tool. IPs must be process drivers and not passive coordinators. So ultimately, the law wants us to become the drivers. We have to take the control of the events, though it might not happen at times. But again, we have to justify our situation that at least we tried from our side. We tried from our level best, and you should always make everything transparent to the stakeholders, whosoever is involved, so that ultimately it does not come to you. So that is the ultimate outcome of this. We can have a short break here, and then we will continue with the cases. It's 11:35 right now. We can come back by 11:45. 10 minutes break. I think that will be sufficient.
Okay, ma'am.
Okay. Can we start the session?
Yes, start please.
Yes.
Yes, please.
Okay, let me just share the screen. So we were discussing these case laws. Let us just complete at least the ICSI cases. So we were here. This case, okay. Balu Sridhar, Rajshri Chaudhary. These are the two IPs in this case. These cases, though decided earlier, were frequently cited in 2022 orders. They dealt with deficient conduct during the insolvency assignments, inadequate attention to statutory responsibilities, and lapses in oversight and compliance. What was the key principle reaffirmed here in these cases? So ICSI IIP repeatedly relied on these orders to reiterate that IPs are individually accountable. Professional obligations cannot be diluted by workload or delegation. Regulatory standards are uniform across the assignments. What was the final takeaway as we can see here? Earlier warnings converted into stricter enforcement in this particular year 2022. Repeat themes attract harsher scrutiny. So if regular defaults are happening, that will bring harsh punishment or harsh scrutiny ultimately. So by the end of 2022, the disciplinary position had become very clear. First, delegation without supervision will amount to misconduct. Second, IPs must be actively involved and not nominal heads. Third, timelines and documentations are not negotiable. Fourth, process integrity outweighs the outcome. And fifth, compliance systems must be robust and demonstrable. So this year, 2022, it laid the groundwork for zero tolerance enforcement, which can be seen in the coming year. So in these 2023-25 cases, we will see this zero tolerance enforcement adopted by the ICSI IIP. So in this part, that is particularly 2023 orders, here ICSI IIP stops treating lapses as correctable mistakes and starts treating them as professional failures affecting system credibility. So these are fact heavy and reasoning driven, and many cases which were there in 2024-25 orders, they simply quote or rely on these principles which were laid down earlier. So this is the first case which we are discussing here. Anish Gupta, insolvency professional. In this case, basically, Mr. Anish Gupta was appointed as insolvency professional in a CIRP. During inspection and subsequent disciplinary proceedings, ICSI IIP found multiple structural deficiencies in the manner the CIRP was conducted. What were the key factual findings there? So they found out that engagement of professionals who had prior professional relationships with the IP. There was a case of non-disclosure of such relationships in mandatory disclosures, heavy reliance on these consultants for statutory compliances, documentation, process execution, etc. There was inability of the IP to demonstrate independent application of mind, personal decision making on these statutory matters. Finally, the inspection record showed that many actions were mechanically executed, with the IP acting more as a coordinator than a statutory authority. What was the issue involved here? What constitutes independence under the IBC regime? So here the term independence was ultimately defined. What do you mean by independence? Then can an IP delegate substantial statutory functions to consultant? So that means the code itself allows you to take help of experts. You can take their expert services, but again, the responsibility is on the IP himself. He cannot shrug off the responsibility totally. So this was the question asked or the issue raised in this particular case, that can an IP delegate substantial statutory functions to consultants? whether absence of financial loss mitigates professional misconduct. What were the violations alleged in this particular case? Again, there was a breach of Regulation 7.2 of the IP regulations, violation of code of conduct related to independence, objectivity, due diligence, and fiduciary responsibility. What were the arguments given by the IP here? IP submitted that engagement of professionals was driven by efficiency and expertise. Prior relationships did not influence any kind of decision making. No stakeholder suffered prejudice. CIRP is practically impossible without any kind of professional support. What were the arguments given by IPA in this regard? Independence must exist both in substance and in perception. Disclosure is mandatory irrespective of the outcome. So, whatever the outcome may be, disclosure is still mandatory. So, if any IP has failed to disclose, that will tantamount to misconduct. Then consultants may assist but cannot replace the IP's judgment. IPs are custodians of the insolvency process and not the project manager. So these last 2 points are again very important, that consultants can be taken, we can take help of these consultants or experts, but ultimately the accountability will be on us only. So whatever they give their report, whatever they conclude in their findings or in their proceedings, we also have to apply our mind and finally check whether the report is matching the standards and whether everything is being taken care of. So ultimately, our perception also matters. If you are simply laying their report on record, that will not suffice. So it is the duty of the IP to basically cross-check whatever these experts have done, because ultimately it will always be the responsibility of the IP. You cannot shrug off your responsibility. In one of the cases, it was, so I'm deviating from this particular case. I just have one case to be quoted here, wherein a valuation report which was given by a valuer was produced as it is to the adjudicating authority. Then finally it was concluded by them that it is not the final decision which will be made by the valuer. Ultimately, there is no substantiation that IP has also applied his mind, IP has done any work on that. So if you are just producing the same report to the authorities without making your, conclusion over the report, you should also, make some points from your side also, that why you believe on that report, or what are the factors on which you rely on this report. At least give some note in relation to that. So if you are not giving that, again that will not be taken as a record as such. So ultimately, what we want to mention here is you cannot simply rely on the experts or the other persons whom advices or services you have taken. Ultimately, you have to cross check, and how you can do that, how you can document all that, you should take the workings of these experts. Since we are paying them, we can also ask for their workings. That will be our document, that will be our evidence for the future, that yes, we have cross-checked their working, we have checked what all report they have drawn based on these conclusions and all. So that is what we must check, cross-check in fact. So we must ask what all requirements, what all parameters they searched for, whether they, if we are talking about the valuation, whether they adhere to the proper valuation standards or not. So that kind of cross questioning can be done, and this has to be again documented for our purpose. Moving to this case again, what were the findings and reasoning in this regard? The disciplinary committee made strong system level observations. An IP is a fiduciary of the insolvency framework. Disclosure obligations are preemptive safeguards. Delegation which dilutes accountability amounts to abdication. No loss arguments are irrelevant in disciplinary jurisprudence. So if you are just saying that there is no loss, that argument will not take a very good position here, and that will be actually irrelevant for the proceedings. The committee emphasized that the credibility of IBC depends on visibly independent IPs. So how do you show that you are independent? So visibly you have to appear as if you are independent. So that is what finally it was clearly, I mean, it was hinted in this that you are not just independent on papers, but actually you should appear that way also. The IP was held guilty of professional misconduct. Disciplinary directions were issued, including warnings and enhanced compliance expectations. So, what is the takeaway for all of us? Independence is judged by conduct and not intention. Always disclose past, present, and potential conflicts. Consultants can support, but ultimately IPs have to decide and remain accountable. System credibility outweighs the individual convenience. Next case. It is Madan Gopal Jindal's case in 2023 itself. So, Mr. Madan Gopal Jindal acted as an insolvency professional in an assignment where inspection revealed significant procedural lapses, delay in statutory actions, inadequate documentation of the decisions, failure to maintain proper records. The IP argued that the lapses, just a second. The IP argued that the lapses were isolated and caused by external dependencies. What was the issue involved? Whether failure to maintain proper records and timelines constitutes a misconduct. Whether operational difficulties excuse non-compliance. So these two factors, I mean, this is very common that we may say that due to operational difficulty, we could not comply with the norms. Or sometimes we fail to produce proper records. So this case is very relevant in this regard. So what were the arguments given by IP? Delays were beyond control. There was no malified intent, however. Process was ultimately completed. The IPA, on the other hand, argued that IP is the process controller. Documentation and timelines are core obligations. Completion does not cure procedural defects. So this is, I mean, this we had discussed earlier also, that even if the process is completed satisfactorily, still if there are any procedural defects, it will not cure the deficiency of, or it will still be considered as a misconduct on the part of the IP. Findings and conclusion. The committee held that poor documentation undermines transparency. Timelines are statutory and not aspirational. IP must proactively manage dependencies. What is the final takeaway? Record keeping is a governance obligation. IPs must be process drivers and not coordinators. So ultimately, see, many a times it happens that things go beyond control. We are not able to proceed in time. But how to safeguard ourselves? Because this will happen. It is never, mostly it never happens that within the window of 180 days, you are able to complete each and everything. It never happens that way. So how to safeguard yourself? The best thing is to have proper documentation of each and everything, that you started the process in time, but it got delayed due to this reason. You had brought everything into the COC meeting, you had discussed everything, whatever the minutes are, it has to be very explicitly mentioned, each and every detail, whatever was discussed, why it was not taken further, or whatever the case may be. So everything has to be documented. So this will obviously be a kind of safeguard for all the IPs. Next case is
Ma'am, just a question.
Yes.
Are these case laws and these orders available somewhere for the other
Yes, ma'am. Yes, they are. So
Okay.
once I finish, I will even take you where these cases are listed.
Understood. And
Yeah,
also, if possible, if sector-wise cases, because in every the kind of sector where we are RP, the kind of queries and and the what we say, the litigity and everything changes with the case laws with the
Yes. Each
sector
and every
also.
case is different, ma'am. So
Absolutely. So
obviously,
so I don't know how they've categorized there. So if it be sector wise, because in related sectors where there are multiple home buyers and all, deal with them is difficult there. So let us know there how they have bifurcated the orders there.
Orders are not bifurcated as such, ma'am. They are just put date wise.
Okay.
So whatever order has come up, so it is sequentially mentioned. You have to read each and every case to find out whether it relates to you or not.
Have
Sometimes,
you covered likewise that? No. Okay.
actually, this particular session is for the disciplinary issues only. So for disciplinary cases, for maybe for the independence and for other matters, I have segregated that way. But since you are asking the sector wise, that is from the point of view of CIRP or liquidation.
CIRP, actually,
Yeah. So
especially
that
for the
is,
real estate matters, one of the cases real estate where
yeah,
home buyers keep asking so much documents. So we
yes,
should be very clear because law is also silent there. So there's
yes,
clarity how much RP is required to respond to each and every query of, because there are thousands of home buyers. Is RP
yes.
bound to reply to each and every question and document they're asking for? So in case IBB has any such case has been there, so it would help, many IPs who are working. This is the most complex sector to work with, actually.
Yes. I have taken that in my PPT, ma'am. One of this, I have not. There is no actual case law related to that, but yes, this question has come up earlier also in one of my sessions, that how to respond to so many home buyers and what documents we can keep for them. Because how will we be able to, say that we have been answering to all of them? Because anyone can complain at any point of time.
Absolutely.
So,
That's why I wanted if this
yes,
point can
yes.
be taken
This
up.
this point is taken up, ma'am, in one of my slides. It is there.
Okay, thank
So
you.
let us first complete these cases which are there, and then we will take up the individual these complex cases or whatever you say in particular scenario. We will take that up also. Okay.
Noted.
So in
Thank you.
this particular case, what has happened is, the inspection revealed that the IP had failed to exercise adequate professional care. Certain statutory functions were treated mechanically, and there was lack of evidence of independent judgment. Issue was whether lack of diligence and mechanical compliance constitutes misconduct. The committee held that the IP must demonstrate application of mind. So this is again, coming up in many cases, that IP must demonstrate his application of mind. So how do you demonstrate that you have applied your mind? So even if you have the report of the valuer or any of the experts in your hand, you cannot blindly rely on that. That you should again have one paper from, one document from your side mentioning the facts that I have checked this part, and maybe because of these factors, I'm relying on this report. It has complied with all the regulations and it is satisfying all the parameters, and something from your side should be there so that it demonstrates that you have not blindly accepted what is given to you, but you have also checked it. That is what you cannot drill down again into that thing, because it will again take a lot of time. But it is simply that you have to show that at least you have read the report, you have gone through the working, you are satisfied with the work done by the expert. Or if you want some cross questioning, or if you have cross questioned, that is also to be mentioned, that I asked a particular thing which was missing in the report, I asked them to redo it and redraft the report for me. So that can also show that you have applied your mind. So mechanical compliance is inconsistent and with the fiduciary role. What is the takeaway here? IPs must actively think, decide, and document. Compliance is qualitative and not just quantitative. So again, I think this idea is clear till 2023. In 2024, what was the scenario? The focus now shifts to, was the process conducted exactly as the code regulation requires? So now again, they are becoming more strict, whether it is being done in as it is manner. That is what they want us to do. So these cases are extremely important for practicing IPs, because most current inspections and show cause notices mirror the reasoning used here. So we are discussing the cases of 2024. So, in this case, particularly of this insolvency professional, Mr. Pinakin Surendra Shah was appointed as insolvency professional in a CIRP. During inspection by ICSI-IIP, several process level deficiencies were identified, including delay in constitution of the Committee of Creditors, delay in completion of certain statutory milestones, inadequate explanation for deviation from the prescribed timeline. So again, if you can see here, there was inadequate explanation. He could not explain why he had deviated. So that is something which you have to keep a record of if you want to just escape from the disciplinary issues. So first of all, you should try not to delay the proceedings, but obviously it is not in your control at all the times. Then you have to do not keep the things to yourself. Just make a note of it, or at least produce it in front of the adjudicating authority that it is causing delay. COC is not letting things to happen in time, or whatever. If anything is being controlled by COC and they are not allowing things to be done in time, then you can always report that out. And you should keep a noting of each and everything, each and every detail with you. The IP argued that the delays were caused by practical difficulties in receiving claims, stakeholder coordination issues, and operational constraints inherent in the insolvency proceedings. So what was the issue involved here? Whether delays in COC constitution and statutory actions constitute the misconduct, whether practical difficulties can justify deviation from IBC timelines, whether absence of stakeholder loss mitigates liability. What was the violation alleged here? Breach of section 21 and 22 of the IBC, violation of CIRP regulations relating to timelines, breach of code of conduct requiring diligence and promptness. Let us see the arguments of the IP here. IP contended that timelines under IBC are challenging in the real world scenario. Delays were not intentional. The process eventually moved forward without any prejudice to the stakeholders. So in each and every argument of the IP, we are saying that ultimately the outcome was, we had the outcome in the fair manner. So no prejudice to any party. Then why you are creating disciplinary action against us? So basically that is the argument given by the IP. So it was not intentional and everything, but still these cases happen. So argument by the IPA here. IBC is a strictly time-bound statute. IPs are expected to plan and anticipate the difficulties. Only judicial or statutory extension can justify the delay. So if there is any kind of delay, you should always have a proper extension. So that is what here it means. Practical inconvenience cannot override statutory discipline. Findings and reasoning in this regard. So the DC held that the constitution of COC is a foundational step in CIRP. Delay at this stage itself affects the entire insolvency framework. IPs are expected to manage constraints proactively. Absence of loss is irrelevant in determining professional misconduct. What was the final conclusion? The IP was held guilty of professional misconduct. Disciplinary directions were issued emphasizing strict adherence to the timelines. Takeaways for the IPs. So timelines are mandatory. For us, at least, timelines are mandatory and they are not flexible at all for us. Planning failure are treated as professional lapses. Practical difficulty, you cannot take that as a defense. Next case, again, we have, let's see if it is something different, we can take it in detail. Here in this case, inspection revealed that, inspection revealed that IP had delegated significant CIRP responsibilities to the consultants. He failed to adequately supervise or review the work done. He relied heavily on the third-party inputs without independent verification. I think this we have already covered, so I'll move forward. We will just see the observations directly. The committee held that delegation without supervision is abdiction. IP must demonstrate the application of mind, this we have seen, and errors of consultants are treated as errors of the IP. So you cannot say that this was not done by me. Okay. So here again, it was established that there was a case of professional misconduct. So advisors will support, they can be taken for support only, and ultimately it is the responsibility of IP. He will be responsible. That is the case it was discussed here. Next case, let's see. Mr. Avinash Atmaram Bagul was proceeded against for deficiencies in claim verification during CIRP. Inspection revealed that claims were admitted without proper verification. Supporting documents were inadequately examined. There was insufficient reasoning recorded for admission or rejection of the claim. So again, this is very important. If you are not recording sufficient reasons why you have admitted or rejected the claim, then again, it may create problems. So what is the issue involved? Whether claim verification is a core statutory function. Next, whether reliance on claimant's submission is sufficient. Whether inadequate verification constitutes misconduct. So this is the major question, whether inadequate verification constitutes misconduct. Violations alleged. Breach of CIRP regulation relates to claim. Violation of code of conduct requiring diligence and care. What was the argument given by IP here? Time constraints required reliance on documents submitted. No fraudulent claim were ultimately admitted. Verification was done to the extent practicable. The arguments given by ICSI-IP, they contended that the claim verification is a foundational responsibility. IP must independently satisfy himself. Lack of reasoning undermines transparency and stakeholder confidence. Findings and reasonings. The committee held that claim verification is not a mechanical exercise. IP must record reasons and conduct reasonable checks. Time pressure does not excuse inadequate diligence. So we all understand the practical thing, but here, if anything happens in in case of if the matter goes to any IPA or disciplinary committee, then obviously this will not be taken as a ground for excuse. Next, what was the final conclusion here? The IP was held guilty of professional misconduct. What is the final takeaway? Claim verification is the core fiduciary duty. Documentation of reasoning is essential. No wrong claim admitted cannot be taken as a defense. Even if you are saying that we have not taken any wrong claim, but still, I mean, you have to justify whatever you have done, you should have proper reasoning for it. So, what is the final outcome of these 2024 cases? IBC operates on strict liability principles. Timelines, disclosure, and diligence are non-negotiable. Delegation without control equals misconduct. Claim verification attracts highest scrutiny. Process integrity overrides convenience and outcome. So if we go to 2025 orders, they are much more strict. Let's see. This is the case of Anna Singaraju. Okay. So here, the IP is there in a case of CIRP. During inspection, it was observed that professional fees were drawn during CIRP. There was no explicit approval of fees by the COC. So this is a matter related to the fees, professional fees. There was no explicit approval of fees by the COC. This is being highlighted here. Minutes of COC meetings did not record any resolution approving the fees. Supporting documentation for fees determination was inadequate. So again, you have to be very, very cautious while documenting regarding your fees. At least you have to mention it in the minutes. So supporting document has to be there for the fees. That is what we should be aware of. The IP argued that services were rendered bona fide and the fees was reasonable. But obviously it was verbal only. So issue involved here, whether professional fees can be drawn without explicit COC approval, whether implied consent or reasonableness can substitute formal approval. The violations alleged are violation of CIRP regulation relating to CIRP cost approval, breach of code of conduct requiring transparency and accountability. See, if you can see, there is a clear-cut clear-cut violation of CIRP regulation, which is specifically related to CIRP cost approval. So you have to take the approval of the cost in all in all cases. Arguments of the IP in this regard: work was actually performed, fees were reasonable and in line with the market price. No objection was raised by the contemporaneously by this COC. Arguments of ICSI-IIP: fee entitlement flows only from approval and not from the effort. Silence of COC does not amount to consent. IPs cannot self-assess or self-withdraw the remuneration. What were the findings or the ultimate reasoning? The committee, the disciplinary committee held that COC approval is a condition precedent. So it's a prior condition. You should have the COC approval. Then next, professional discipline does not recognize implied approval. Fees discipline is central to stakeholder confidence. What was the final conclusion? Professional misconduct was established and disciplinary directions were issued. So ultimately, what is the takeaway for us? If there is no written approval, there is no lawful fees. Even if you say so, it will not be admitted that way. Document approval clearly in COC minutes. It has to be there. Proper approval should be mentioned in the COC minutes. Next case. Mr. Prabhakar Kumar was subjected to inspection by ICSI IIP. During inspection, multiple notices seeking information were issued. Responses were delayed or incomplete. Documents were furnished only after repeated reminders. So again, this shows that a communication gap between IPA and IPs here, and ignorance, or you can say that they were not. IP did not laid any kind of priority to these communications. So the IP cited workload and administrative constraints. That is why he could not reply to those notices. Issue involved whether delayed or partial cooperation with IPA constitutes a misconduct. Yes, it does. Breach of Regulation 72H, that is duty to cooperate with IPA. So there is clear cut. In fact, separate subclause for this thing that you have to follow. There's in these regulations, it is clearly mentioned. Violation of code of conduct relating to regulatory cooperation. So even if you do not have any kind of intention to, disregard them or whatsoever, still you will be held guilty for that. So timely cooperation is mandatory. Delayed compliances defeat the regulatory supervision. That was the argument given by the IPA in this regard. So ultimately, it was held that intention is irrelevant, basically, and the delay itself constitutes a misconduct. So cooperation with IPA is a statutory obligation. So always treat IPA notices as priority. Statutory communications. Delay is a standalone violation. Next case, let us see if the facts are similar or what. During inspection, disclosure filed by IP were found to contain inaccurate information, inconsistencies across reporting periods. So this may happen at times. So this, what is happening here is, you are filing the disclosures, you are timely reporting out things, but the information is not accurate, or there is inconsistency across the reporting period. So in one of the reports, you have reported out something else, and in another report, you are maybe reporting something else. The figures are not matching, or the things are not making sense. They are not synchronized. So if there is any kind of inconsistency, what can that be? The IP admitted these errors and described them as clerical. What was the issue involved? Whether incorrect disclosure, even if unintentional, amount to misconduct. So the violations alleged here are misrepresentation through incorrect filings and breach of disclosure and transparency obligations. What was the argument given by the IP? The errors were inadvertent. There was no intention to mislead. However, the IP argued in the other way. It said that the disclosure regime operates on strict accuracy. IP bears personal responsibility for correctness. See, sometimes it happens that a staff changes. Whosoever has prepared the earlier report might not have be available to prepare the next report. So sometimes there is a obviously if you are not properly documenting the things, you are not having the proper records. Sometimes it may happen that even if not intentionally, there might be some inaccurate information or incorrect information which is floating to the IPAs or any other body. So in that regard, this case law is important. The committee held that disclosure accuracy is a continuing obligation. Clerical errors do not excuse professional misconduct. What is the takeaway for us? Again, it is said that personally you have to verify all the disclosures, because ultimately you will be held liable or guilty for that. Accuracy matters more than the intent. Next case. this order reaffirmed and relied upon. So there was a previous order and it was reaffirmed in this particular case. The earlier findings on independence, disclosure, and delegation were reiterated here. I think we can skip this one because we have not read the earlier one. So what is the final takeaway for all these cases? So this is the crux of these disciplinary cases. What is the nature of IP role? IP is a fiduciary of the insolvency process. He is not a service provider, agent, or the stakeholder nominee. He should act independently. That is something what is meant here. Next, disclosure and independence. Disclosure obligations are absolute and continuous. Perceived conflict is sufficient for misconduct. Next, regarding delegation, assistance is permitted. However, responsibility is not delegatable. Delegable. Next, timelines and process. IBC timelines are mandatory, at least for IPs, it is mandatory. Practical difficulty is not a defense. Next, regarding claims and fees, claims verification is a core statutory function. Fees require explicit recorded approval. Even it is for us or for the valuers or any other experts you are appointing, you should have proper disclosure, proper approval for that in the minutes. Next, regulatory cooperation. IPA, IBBI oversight must be met with prompt, complete cooperation. Okay, so we are done till here. Then let us now discuss the code of conduct, which will really guide us at which point we have to be careful. Just a second. I hope it is visible now.
Yes, yes.
Okay. So actually, as I had mentioned earlier also, that IPAs have a monitoring responsibility. They monitor the work of IPs and time to time they issue guidelines also. So I'm sharing the guidelines issued by Triple IPI here. So they have issued a handbook for do's and don'ts, what IP should do, what IP should not do. So in that regard, with respect to the code of conduct, they have clearly mentioned it. So normally what happens that IPAs issue the guideline, but since we are involved or engrossed in our day-to-day work, we do not see these guidelines which are there very handy for us. Therefore, these sessions are conducted and maybe we can quickly brush upon what is mentioned here. It is not to be, mugged up each and everything, but at least if we go through it once, then we might remember if we have any kind of confusion, we can resolve it then and there. So regarding integrity and objectivity. So for this code of conduct, if you know, there are various clauses which are there. So with respect to each and every clause, particular things are mentioned in this. So regarding integrity and objectivity, an insolvency professional must maintain integrity by being honest, straightforward, forthright in all professional relationships. Appointments of professionals must be transparent, at arm's length, without conflict of interest, with clear scope and remuneration. So all these points should be, clearly mentioned at the time of your appointment. That the fees is as per is at the arm's length. There is no conflict of interest and everything. Regarding independence and impartiality, an insolvency professional shall maintain independence in professional judgment. He shall not continue assignment if independence is compromised due to personal, professional, or financial relationships. So he should not wait for others to tell him. He should, on his own, get off the assignment, or if at any time he thinks that his independence is compromised, he should move out of the assignment. Next, regarding professional competence, an insolvency professional shall maintain professional knowledge and skill at the level required to ensure competent professional service, keeping updated with legal and regulatory developments. So professional competence is again required because you cannot keep on doing the things with the same set of knowledge. every day you find something or the other happening in the surroundings or in the economy or in the law itself. Everything is changing or it is evolving, so you have to be regularly updated, and these sessions are very important to just update. So many circulars are issued, even the law keeps on amending, so everything you should be aware of, because while dealing with the case, when you started off, the scenario might have been different, but after 1 year or 2 year, the things might have changed. There might be some settled decisions for that particular case, so you have to be updated for that also. Representation of correct facts. An insolvency professional shall represent facts truthfully and shall not misrepresent or suppress any material information, and shall correct any misapprehension immediately. Next, regarding timeliness, an insolvency professional shall act with timeliness. In all professional assignments, delay defeats the objectives of the Insolvency and Bankruptcy Code. So this is just the, simple idea, but again, this is a very detailed guideline wherein examples are also quoted as to where you might face difficulty, and in a particular scenario, how you should take that up. So I will take that also. I think there is a separate slide for that. I will take that. Before that, I will take the main presentation wherein the code of conduct, because some of you might not even remember what are the clauses in the code of conduct. So we must first check the code of conduct itself. Just a second. Okay. Let me know if my screen is visible. Is it visible now?
Yes.
Okay, so regulation 72H, it requires IPs to comply with the code of conduct, which is specified in the first schedule of the regulations. Regulation 11, it talks about the disciplinary proceedings. Here, IBBI can initiate actions like suspension and all. We have checked that out already. Disciplinary approach can be different from both of these authorities. IBBI can have their own disciplinary approach, and IPA can also have their own. So IBBI conducts inspection or investigation under section 218. We have seen that. It may file a complaint with, anyone can file a complaint with the disciplinary committee under section 220. DC may impose penalty, suspension, or cancel the registration. Ultimately, that will be the case. In case of IPAs, if it receives any kind of complaints or reports from IBBI or stakeholders, it will initiate the proceedings. It will refer the matters to Grievance Redressal Committee and MDC. Actions include reprimand, suspension, delisting, and training mandates. Sometimes it is also asked that IP should undergo mandatory 10 hours of training, the CPR session, or 30 hours of CPR session, so as to refresh his knowledge. That may also be the possibility. So these are the disciplinary trends. I think before this, this is the code of conduct. Here, I think we have to pay attention. Okay, so if we talk about the code of conduct, there are various clauses. So from clause 1st to 5th, it talks about the integrity and fairness. Here it says that IP must act honestly and not misrepresent. He should avoid disrepute and prioritize public interest. So these are the 4 things. If you 4-5 things, if you keep in your mind, you will fulfill the criteria of integrity and fairness. He must act honestly. He should not misrepresent. He should avoid any kind of disrepute, and he should prioritize the public interest. Next, clause 6th and 7th, they talk about the professional competence. Here, IP must act with care, follow the standards, and exercise due professional judgment. Clause number 8 and 9, they talk about confidentiality. Ultimately, it summarizes that any IP has to maintain confidentiality unless legally obligated to disclose. So this is again very important. Understand that you have to maintain the confidentiality of the information, But if IPA is asking you for the information or IBBI is asking you for the information, and if you are not providing the information to them, then again it is causing a breach of this confidentiality clause. Because here it is clearly mentioned, unless legally obligated to disclose. If you are asked to disclose and you are not disclosing it, then again it causes a breach of confidentiality. Next, clause 10, it talks about the representation of facts. Here it says that you have to avoid misstatements or correct any misapprehensions if there is any. Next, clause 11 and 12, they talk about disclosure of interest. So IP has to disclose conflicts and relationships with stakeholders at any point of time if it is there. Next, clause 13 and 14, they talk about timelines, timeliness and diligence. So it is said here that you have to follow IBC timelines and act responsibly with urgency. So you cannot say every time that we just do not have any power or we are helpless, the things are not going on. You have to take the rigor, you have to be the driver, and ultimately you have to find the solution how to trace that out. Let me just give an example. Sometimes, or most of the time, it happens that we do not have sufficient records to start the proceedings. The accounts are not available. How to get all the records? So we should not just rely on the corporate debtor to provide us the details, because for them, for non-cooperation, obviously we file this 19(2) application, but there are other methods also to recover the records. You can ask the creditors to provide the information, whatever they have. You can take the information from the GST portal or the income tax department, or from the MC also. If timely filings have been done, there will be sufficient data which can help you start with the work. So you just cannot sit idle and just wait for the things to happen. You have to again and again check with various authorities how you can get the things going. So that should be your task. Next, clause 15 and 17, they talk about communication and records. Maintain contemporaneous records, simple stakeholder communication, and legal cooperation. This is what is required of this. So again, this communication and records is very essential in each and every case. And if it is a matter of real estate case, obviously that is very, very important, because whatever is being decided, if it is not communicated to the stakeholders, that will create kind of gap between the between the IPs and the other stakeholders. So everything has to be recorded and it has to be properly communicated also at times. So how to do that? You can have
solution to
can others please mute? Next, clause 18 to 20, regulatory cooperation. Tejasvi, please mute yourself.
और क्या नहीं था the positions.
Tejasvi, please mute yourself. Yeah, clause 18 to 20, it talks about the regulatory cooperation. Here it is advised to cooperate with IBBI, IP inspections, provide data for audits and research. So you have to cooperate with the regulators. That is also a clause mentioned in this code of conduct. Then clause 21 and 22, this is regarding the fees and cost. So here it says that you have to charge reasonable amount, you have to disclose it, and you have to get approved fees. So all these things you should remember regarding fees, as well as any other cost which is being incurred. So everything is to be put in front of the COC meetings. You have to get the approval for that, and obviously it has to be properly disclosed. Next, clause number 23 to 24, they talk about the gifts and inducements. So IP should avoid receiving or giving any gifts that affect the independence. So even if, sometimes it happens that we meet the stakeholders outside the main premises or wherever. So in that case, you should try and avoid receiving or giving gifts at any point of time, because it will affect your independence. Next, clause 25 to 26 promotion and public communication. So no misleading promotions or unapproved representations should be there. So ultimately, this will disrepute the IP or the institute altogether. So ultimately, there should not be any misleading promotions or unapproved representations. So there are some specific application of ethical framework. So how you can apply it in day in day out basis. So accepting assignment, at the time of accepting the assignments, what you should be very cautious of, that disclose prior relationships or conflicts, withdraw if independence is compromised. So both the things should be remembered. If you have any prior relationships or any kind of conflicts, you have to disclose that. And if at any point of time you think that your independence is being compromised, then you should withdraw from that assignment. In case of conflict of interest, what you should do is you should clearly identify and document potential conflicts, whether it is related to business, family, advisory role, etc. There is a particular case for that, Delhi High Court and IBBI DC orders, which they stress separation from conflicting parties. So if there are any parties with which there could be any kind of conflict of interest, it's better to separate yourself from them. Otherwise, if you do not do it on your own, there might be some disciplinary action based on this point. Specialist advice and services. Select based on merit and avoid selected party favoritism. Report if there is any kind of misconduct. So this is very, very important. You cannot have favoritism in appointing any experts or any other person. So you should always select on the basis of merits. Next, regarding gifts and inducements, you must not accept hospitality or gifts that compromise the independence. Next, advertising or promotions. No misleading claims or fees manipulations. Next, dealing with assets. While at the time of dealing with the assets of the corporate debtor, IPs and relatives must not purchase assets from the corporate debtor to avoid the bias. So even if IP or any of the relatives, if they are participating in the bidding process or anything, then that is a clear-cut demarcation here that they should not get into the purchase of the assets. Otherwise, it may call for a disciplinary action. Next, employment scenarios. Ethical obligations persist even as employees resign if unable to uphold the principles. So this ethical framework does not apply only on the IPs who are practicing. It even applies to them who are working as an employee. So even if you are not holding AFA, you are working as an employee, and you think that some kind of independence or some kind of ethical obligations are hurting, you are not able to uphold your principles, then it is better to resign. So this is a guidance given by the IPs from time to time, that even if you are in employment, you are IP, then you have to follow these code of conduct. So irrespective whether you are practicing or not, you have to follow the scenario. If we talk about the ethical principles for IP, you have to abide by this integrity, objectivity, competence, confidentiality, and the professional behavior. We all understand that with respect to integrity, we have to be very straightforward and honest. With respect to objectivity, we should not compromise professional or business judgments. With respect to competence, we have to attain and maintain professional knowledge and skill. You should keep on updating yourself. You should be updated with the case laws, whatever are happening at various forums. So regularly it should be a practice. Then confidentiality, we have discussed not only at the time of having the assignment, even if you are not on the assignment, then also you have to keep the confidentiality. And then for the professional behavior, you should avoid any conduct that the IP knows or should know might discredit the profession. Okay, so sometimes it happens that whom should I consult for guidance? If there is any situation which is causing any kind of confusion, whom should you ask? Because you are saying that everything has to be documented. How should I keep myself, away from the disciplinary action. So how you can go ahead? You can take help of the legal counsel. You can take help of the professional bodies. Sometimes industry specific professional bodies are there. You can take help of them because uh, every case is different. Every industry is different. You do not know everything of that industry. So you can take help of that professional body. Then you can take help of another IP. So all the IPs are very helping and they always share the experience with each other. So you can always take their advice. Then the regulatory bodies like IBBI or IPA, you can seek advice from them. You can write a mail to them mentioning your query and you can seek their guidance. And again, if you are a partner in any IPE, you can consult among the team itself. That is how you should pursue. Some more important points: an IP should continue to comply with the principle of confidentiality even after the end of the relationship between the IP and the employing organization. This we have already discussed. Then, changing employment or accepting an insolvency assignment, the IP is entitled to use prior experience but should not use or disclose any confidential information acquired or received as a result of a professional or business relationship. So, whatever information you might have received during your employment or being on any assignment, you should not disclose it to other people. So, that is the purpose of having confidentiality. That is what is required. An IP should not knowingly engage in any business, occupation, or activity that impairs or might impair that the integrity, objectivity, or good reputation of the insolvency profession, and as a result would be incompatible with the fundamental principles. So again, if at any point of time he is found guilty, then he must be able to prove that he did that unknowingly. So he has to prove on his part. Then IP should, what he should do first, he should exercise his professional judgment. He must remain alert for any new information or changes in facts and circumstances and use the reasonable and informed third party test. So that is the core of it. Ethical framework, we all understand. Again, if there are any kind of threats, like threat of identification, if you are not able to identify something that always remains a threat, you should document it somewhere according to you. And if you are, suppose, if you are not able to evaluate something properly because of lack of documents or something, then again you should kind of document it. So you should have proper safeguards so as to comply with the role. That is what is it. Some more important points: the IP should form an overall conclusion about whether the actions that the IP takes or intends to take to address the threats created will eliminate those threats or reduce them to an acceptable level. So don't keep the things in your mind that you are assuming that this will be a threat and you have taken an action based on your own imagination or everything. You have to document it. That is what it is mentioned. I'm just reading it again for you. The IP should form an overall conclusion about whether the action that the IP takes or intends to take to address the threats created will eliminate those threats or reduce them to an acceptable level. So, firstly, you have to identify the threat, what actions can be taken to mitigate the threat, or how you will address that threat, or how you came to the conclusion that this is how we can do all the things. So everything has to be documented. In forming the overall conclusion, the IP should review any significant judgments made or conclusions reached and use the reasonable and informed third party test. Record keeping is a must. You have to keep each and every kind of record, because whether we are CA or CS or lawyers, in every profession we are taught that record keeping or the documentation is, very helpful in by proving or justifying how we came to the conclusion that way. So if you are in IP, again, the record keeping will save you at many point of times. So the IP should document the facts, any communications with and parties with whom the matters were discussed, The courses of action considered the judgments made and the decisions that were taken. The safeguards applied to address the threats when applicable. How the matters was addressed, where relevant, why it was appropriate to accept or continue the insolvency assignment. So even see this F point, it clearly states that even if you are having some kind of conflict of interest, or maybe you are having some related party association or whatever, you are still continuing the assignment. In that case, you have to make a proper or appropriate note why you continue, what was the reason how you managed to continue. So why it was appropriate to accept or continue the assignment, you have to keep a record of it. Next, the IP should document the substance of the issue, the details of any discussions held, and the decisions made concerning that particular issue. I think we can go for this. The question, ma'am, you asked regarding the real estate. So there could be a question like, many a times discussions are held on phone or across the table with the stakeholders, with no practical possibility of minuting such discussions, particularly in real estate cases with a lot of phone calls coming from the home buyers. So what can be done in that situation? Home buyers usually are considered as the operational creditors, and they call very frequently with queries, grievances, and various kind of requests. Many calls are individuals and informal, with no COC-like structure. Time and volume make formal recording impractical. So we cannot keep on recording the phone calls. It is not practical at times. Oral assurance can be misinterpreted or later misrepresented also. So even if you assure them orally on phone, so that might be taken as a, that could be taken as a misinterpretation or misrepresentation at times. So you should avoid the oral assurance. So how you can deal with the situation? What is the regulatory and ethical expectation from us in this regard? Clause 7.4 of the IIIPI, I'm taking that part. An insolvency professional shall ensure that all communication with the stakeholders are recorded and retained in a manner that they can be made available for review. This is what is expected of us. Clause 9.1, it says regarding the professional behavior, avoid situations that impair the integrity or objectivity of the profession. Even perception matters. IBBI guidance note also says something here. Communication with stakeholder must be consistent, non-preferential, and backed by the records wherever feasible. So what should we do? So best practice in this case could be standardized written communication. Issue monthly updates to all the home buyers. So whatever the discussion is, you issue monthly updates. So we cannot make everyone understand everything. So at least we can show that, yes, we tried to update them. That is it from our side. So how we can do that? By forming a WhatsApp broadcast list, or we can form an email group. We can circulate the messages regularly. Publicly posted bulletins on the CIRP website. You can publicly post that also. You can include case status, court updates, key timelines, and the decision. So if there is any particular decision has case law is there for this real estate, which is resembling to your scenario, then also then you can post to show that, yeah, some kind of similar thing can happen in our case also. So regular court updates can be posted. Then again, timelines and decisions also should be posted, because again, we have to make the people aware, because they are not the learned person. These home buyers, we cannot teach them each and everything, but we should make them aware that this process goes by some timeline. So within this timeline, we have to form our opinion, we have to circulate the reports and everything. So again and again, we have to tell them. Template responses for the phone queries. We can form some templates for that. Prepare FAQs and response scripts for the team. So if your team is taking the phone calls, you should have this proper, you can prepare some kind of FAQs that you can ask name of the person, he's calling from which place, or maybe something which the team will record in every case. Avoid giving individual legal opinions or assurance over the phone. Record basic logs like caller name, date, issue raised, and even if it is not verbatim, as it is, you should not record it. It may not be possible also, but at least what was the issue read in short, at least that can be recorded. You can make a register, call register, wherein you can record all that. You can use email or web forms to capture the concerns. Politely, you can request home buyers to follow up phone queries with email. You can ask them whatever you have just inquired from us, you can just send us a mail also in that regard. And if they do not mail you, you should mail them saying that this was what discussed with you or with any person. So from your side, you should have things in writing. So after a phone call, make it a habit to send them a mail. This can help you out. Submit structured issues via Google Form or portal. This provides a verifiable trail. Group calls over individual conversations. So avoid individual conversation. Rather, you can have a group call. You can call small meetings with these people, maybe over, you can use virtual meetings also. You can have that, or you can conduct monthly town hall style webinars, record the session, share minutes on websites or email. Disclosure in COC meetings, present a summary report of the stakeholder queries received and action taken. For example, these calls or emails received from home buyers in last 30 days, major concerns were so and so, and these are the actions which has been taken for that purpose. So ultimately what we can say here is these are the risk areas which we have to avoid. You should not, this is a risky area that providing verbal assurances. So concern is it can be misquoted or misused. So how to manage? Always follow up with a written summary. Regarding selective disclosures, it violates the principle of equality. So you should inform everyone uniformly, issue uniform updates to all the stakeholders, not the selective disclosures. Ignore calls from some buyers. If you are ignoring calls, then also it is a risk. It can be seen as a partial conduct. So use a rotation help desk model for responsiveness. So that is it from my side. I think the time is already up. We have few IBBI cases also. If you want, I can take that up, or if you want open discussion, it's okay. Or should I take you to the site where these cases are there?
Yes, that can be helpful.
Okay, sir. So I'll just share my screen. Just wait, I think it's not open. Just a second. Just let me know if you can see the screen. This is the homepage of ICSI IIP, meaning our IPA. Can you see that?
Yes, we can see that.
Okay. So here, if you go to orders, can you see your orders? It will not work unless and until you say yes.
Yes.
Okay. So here in orders, we have IBBI orders as well as ICSI IIP orders. So I have taken this ICSI IIP orders. So these are the orders till date. From 2019 till 2025, I've tried to cover them all. All these you can see. So if you want to see a particular order, we can open one. Yeah, can you see?
Yeah.
Yes. I'm just increasing the font. We can all read it. See, it clearly mentioned that who has issued the order. Then the order number is also there, like this. Then the date is there, and the order is issued under Part 3 of Disciplinary Policy, read with Clause 24(2) of the bylaws of ICSI Institute of Insolvency Professionals. This is the background of the case. So you will have the complete detail here. This order disposes of the show cause notice dated 3rd January 25. So on 3rd January, the show cause notice was issued, and the final order we can see here on 2nd of April, right? So it will give you the complete story. I'll just read it out quickly. This order disposes of show cause notice dated 3rd January 2025 issued to this IP. So all these IPs are mentioned here. They are professional members of ICSI. It is clearly mentioned, and an insolvency professional registered with so and so, and this is the number which they have put it. The first paragraph will be like that only, to whom it is being issued. Then the inspecting authority of ICSI IIP conducted online inspection. So inspection can be conducted online also of 8 assignments. So they inspected 8 assignments handled by her and prepared final inspection report, which was duly mailed to IP on 14th March 2024. The final inspection report was placed before the monitoring committee on 16th December 2024. The monitoring committee, in its meeting, directed the secretariat to issue show cause notice based on the findings. So, firstly, the inspection has taken place. Then the inspection report was prepared. So, in March itself, the inspection started, or the things were mailed. Or then in December, the final report was placed to the monitoring committee, before the monitoring committee, and then the monitoring committee, based on the findings, they issued the show cause notice. The show cause notice was issued by the Secretariat on the 3rd of January 2025. Ms. Anaga sent her reply to the show cause notice through email dated 17th January. So there might be a timeline within which she had to reply, and she replied there. The show
So,
cause.
ma'am, this was suo motu initiated by the ICSI IP, or it was based on some
It was suo motu, kind of. Nothing is mentioned beyond that, so we can assume that this was suo motu. Yeah. The show cause notice was issued by the Secretariat on 3rd January. Where were we? Okay, here. The show cause notice, along with the reply and supporting documents, were placed before the disciplinary committee of ICSI IIP for its disposal in accordance with the code and regulations made thereunder, and she availed the opportunity of personal hearing also. So it was done on 28th February. The DC has considered the show cause notice, the reply of to the show cause notice, submissions which were made by the IP, and any other material which was available on the record. What was the allegation here? The contraventions alleged in the show cause notice and submissions by the IP are summarized as under. First contravention is that in the matter of, so case-wise they have mentioned. So 8 cases were there. Let's see in how many cases she was held guilty here. So in this case, in the matter of Brainer Trade and Fintech Private Limited during CIRP, it was observed that the IP has appointed only one registered valuer for securities and financial assets class. However, as per Regulation 27 of the Insolvency and Bankruptcy Code, we all understand, the resolution professional shall within 7 days of his appointment, but not later than 47th day from the insolvency commencement date, appoint 2 registered valuers. So she appointed one, which is clearly a breach, to determine the fair value and the liquidation value of the corporate debtor in accordance with Regulation 35. Accordingly, ICSI IIP had prima facie opinion that the IP has not complied with Regulation 27 of the Insolvency and Bankruptcy Board of India. Okay, submission made by IP, we can directly take up this. The DC noted that the IP in his reply to SCN submitted that CIRP commencement date was 25th July. The CD did not have any assets in its books except the debtors. The IP appointed one registered valuer as per the regulation, but did not identify any other valuer registered with the IBBI for SFA category in Pune. So this is what the excuse given by the IP. So there was no other person in Pune, so he did not appoint. To seek advice in the matter, RP wrote an email to IBBI also. So okay, this is also mentioned that to seek advice, they have written mail to IBBI whether any CA could be appointed instead. The IP also sent a follow-up email on the same. Unfortunately, no response was received. The registered valuer appointed has given the valuation of SFA to be nil. The valuer which was appointed, they had given the valuation as nil and there was no other appointment. So only one valuer was appointed. The RP is saying that they seek the clarification because they are not getting any other valuer. So can that be okay? But they did not receive any reply. So can that be taken as a plea that I asked various authorities and all? So that will also be discussed. The IP also submitted that the second valuer could not be appointed since there were very few registered valuers under the SFA category registered with IBBI at that date. It was also one of the early assignments handled by the IP. However, no prejudice has been caused to any party due to the non-availability of second valuation report, since the debtors were valued at nil valuation. The IP in the personal hearing sought accepted the violation. However, IP highlighted the point that valuation was nil and it was one of the earliest assignments undertook. So again, he's saying that okay, it's my initial assignment, or it is just I'm not very much experienced in these cases. So analysis and findings. The DC took note of the fact that in 2018, the IP could have appointed unregistered valuer for SFA category since the requirement to appoint only registered valuer came with effect from 1st February 2019. However, the DC considers the submission made by the IP and also took note of the fact that the matter is one of the earliest assignments of IP in the year 2018 and asset valuation was nil. What is the contravention in the other case? So this is the next case. I think we should conclude first of all, where it is. Analysis and finding. The DC notes that under liquidation, so this is the liquidation one. We were not in liquidation. So likewise, I mean the case, you can find the case as well as the proceedings and all there. So this was the case of valuer. What was the final decision? It will be there somewhere. Should I read it completely? We have read till here, no? Next contravention is in the matter of Kohinoor Precision Component Limited. The insolvency professional had not convened any stakeholder consultation committee meeting. So here the meeting was not conducted. Okay. In view of the above, ICSI IIP had prima facie opinion that the IP had not complied with regulation. So what is the submission made by IP? Why they did not conducted the meeting? So let us see what is the thing given by them, or what was the argument given by them. The DC noted that the IP in his reply to SCN submitted that the liquidation commencement date of Kohinoor Limited is 30th September. In compliance with the said regulation, the SSC formed by the IP within the stipulated period and appropriate actions were taken for facilitation of the stakeholders for each class to nominate their representative for inclusion in the SCC. The IP also submitted that till the amendment, the said regulation did not specify the number and frequency of the meetings of the SCC. It was led to the discretion of the liquidator unless requested by the members holding specified voting rights. It was only by way of 2024 amendment that the regulations made it mandatory for the liquidator to convene the meeting every month or at least once in a quarter. She further submitted so everything is there. So during personal hearing sought, IP submitted documentary proof of informing the stakeholder consultation committee through emails. Okay, so what was the final decision? The DC notes that under liquidation process, SCC role is advisory and everything it is mentioned regarding SCC. Then what is the final order? After considering the allegations in the show cause notice and submissions made by IP in the light of the provisions, in exercise of the powers conferred under so and so, Ms. Anaga have violated certain provisions of the code and regulations. However, keeping in lenient view, you can see here, keeping a lenient view, the DC hereby issues caution to the insolvency professional and advise her to be extremely careful, diligent, strictly act as per law, and similar action should not be repeated while performing the duties in future. So that is it. In both of the cases, a lenient view was taken and no penalty action was taken against her. So that is it in this particular regard. I think likewise, you can just read as the time permits. You can read these cases and you can get more clarity on the issues involved with the disciplinary actions taken. Any questions, or we are done? I think the next speaker is also there, or you have your break time, I guess. Anjali, if you are there.
Yes, ma'am. Can we conclude?
Yeah, we can.
Thank you very much, ma'am. The session was very wonderful and interactive. Ma'am, if you have PPTs of the session, kindly share.
Sure, I'll do that.
Session was very wonderful and interactive. Ma'am, if you have PPTs of the session, share. Sure, I'll do that.
Okay, thank you so much. Thank you, everyone.
Thank you very much, ma'am.
Thank you, ma'am.
Okay, thank you.
Thank you very much, ma'am.
Thank you, ma'am.
Thank
Nice.
you very
Thank
much,
you,
ma'am.
thank you, thank you.
Thank you, madam.
Pleasure. My pleasure.
Thank you, ma'am. Thank you, ma'am.
When is the
And
next
now
time?
there is lunch break till 2 p.m. Next session will start at 2. Next session will start at 2.
Okay.
Okay.
बोल। हाँ, अकाउंट को बोल, मेरा भी सेशन चल रहा है। मेरा भी सेशन चल रहा है, 5 बजे होगा। सेशन चल रहा है, अभी बात मत।
Sir, shall we start now?
Yes, we can start.
Okay. 1 second, sir. Good afternoon, everyone. Now the session will be taken by Rajinder Kumar sir on the topic interplay of PMLA and IBC and fraud detection during CIRP. Let me briefly introduce Rajinder sir. Sir is CS, cost accountant and IP. He is having more than 25 years of experience in accounting, finance, taxation, corporate legal affairs, insolvency, restructuring and valuation matters. Sir is also having experience in managing complex insolvency proceedings under IBC, leading corporate restructuring, liquidation, and resolution plans. He has managed multiple insolvency and restructuring assignments across banking, manufacturing, and service sectors. Sir has represented matters before NCLT, ANCLAT, handled legal documentation, coordinated with COC creditors and valuers, implemented governance frameworks and risk mitigation strategies aligned with regulatory norms. Now I request sir to start the session, please.
Thanks, Anjali. Am I audible?
Yes, sir.
Okay.
Yes.
Okay. Good afternoon, everyone. Welcome to today's workshop on interplay of the Prevention of Money Laundering Act and the IBC Code and detecting of fraud during CIRP under the IBC. As you know, in recent years, insolvency proceedings have increasingly intersected with investigations related to fraud, money laundering, and economic offenses. The objective of the IBC code is time bound resolution and value maximization of stressed assets, while PMLA is a special statute aimed at preventing laundering of proceeds of crime and confiscating tainted assets. The interaction of these two laws raises complex legal, procedural, and practical challenges for IP resolution applicants, creditors, and regulators. Now, question comes during the CIRP resolution process, the RP and IRP are entrusted with the management of the corporate debtor, prevention of assets, examination of past transactions, and detection of just a moment, detection of preferential, undervalued, fundamental, and or at these type of transaction. At the same time, enforcement agencies such as ED, SIFIO, and CBI may initiate parallel proceeding, including attachment of assets under PMLA. Actually, balancing these competing statute objective resolution under IBC and enforcement under PMLA is one of the most critical and sensitive aspects of modern insolvency practice. There are so many judicial pronouncements which we will discuss and cover. We will also discuss all the major landmark judgment cases related to this workshop on this topic, such as Swiss Ribbons, SR Steel, Anuj Jain, Axis Bank, Manish Kumar, and Vijay Mandal Chaudhary have clarified important principles of on the coexistence of the IBC and PMLA, the scope of the moratorium treatment of attached assets, clean slate theory, and the duties of and protections available to insolvency professionals acting in good faith. Actually, these rulings have shaped how fraud is identified, reported, and addressed during CIRP without drilling the resolution process. In today's session, our aims to provide a structured and practical understanding of the legal framework of governing IBC and PMLA under these points of intersection, role and responsibility of IRP, RP, and liquidator in fraud detection and reporting, identification of red flags, suspicious transactions, and diversion of funds during CIRP, treatment of attached assets and parallel proceedings, impact on resolution applicants, credit and value maximization, evolving judicial trends and safeguards for bona fide actions of IP. Actually, by the end of this workshop, we will be able to gain a clear and practical perspective on managing fraud-related issues during CIRP, navigating PMLA proceedings alongside insolvency resolution, and ensuring compliance with law while safeguard the core objective of the IBC code. Okay, now in today's workshop, this is the index we will cover. First, we will discuss on preamble. Point number 2, overview of PMLA and IBC legal framework. Interplay between PMLA and IBC. Role of IRP, RP or liquidator in fraud detection. Okay, this is fifth point, is not 8th point. Fraud detection during CIRP, red flags and indicators, process of reporting fraud and coordination with authorities. Another is practical. What are the practical key challenges as a professional we have to face when we are in the CRP process, and also, along with PMLA proceeding is also going on. So what type of practical key challenges we have to face, and what are the criticism in fraud detection during CRP? And we will also discuss the major landmark judgment cases on PMLA and IBC, because when any issues comes during CRP, when we have to face PMLA and IBC, so then we sometimes, or most of the times, we have to refer the landmark judgment cases related on this topic, PMLA and IBC. Now, at last, we will also discuss the FAQs, PMLA proceedings and fraud under IBC. Actually, if the problem comes, so then how we can deal. So these things we will cover in the FAQ session, and we will discuss FAQs. Is this PPT visible to everyone? Is this PPT visible, everyone?
Yes, sir, it's visible.
Okay, okay, it's moving now?
Yes,
No,
sir.
it's not
What's
moving.
the first page? It's the first page only.
It's first page, but
Yes.
you are not, right now you are not, you are unable to see index.
No, no, no. Only your first page.
Okay,
Yeah,
I
the
will
first
attach.
page
I
is
will
there.
again share.
First
Okay,
page is
okay.
only seen.
Okay,
It's been
okay.
seen.
Now it's moving. Now you are able to see
Yes,
index.
yes, sir, it's moving. It's showing the index.
Yes. Now this preamble.
Yes, yes.
Okay, okay. Now I think now it's moving. Okay, now. Okay, okay. See, in index we will cover preamble, overview of PMLA and IBC legal framework, interplay between PMLA and IBC, role of IRP, RP, liquidator in fraud detection during CIRP, red flags and indicators, process of reporting fraud and coordination with authorities, practical key challenges and criticism in fraud detection during CIRP, landmark judgments on PMLA and IBC interplay, and at the last we will discuss FAQs, PMLA proceeding and fraud under IBC. Someone is unmute. I will request you to please mute. Okay. Okay. Now, first is preamble. First, we will understand what is the objective of the PMLA, what is the objective of the IBC, so that we can go through the content or the topic in detail in further slides. The IBC was enacted the primary objective of time bound resolution of stressed assets, maximization of value of assets, promotion or entrepreneurship, and balancing the interests of the stakeholders. The code provides a comprehensive framework for insolvency resolution and liquidation of corporate persons in a creditors-driven process under the supervision of the adjudicating authority. Parallelly, the prevention of money laundering is a special panel legislation aimed at preventing money laundering, confiscation of proceeds of crime, and the combating economic offence that threaten the integrity of the financial system. The ED is empowered under PMLA to provisionally attach and confiscate properties involved in money laundering, irrespective of any civil or commercial proceedings. Actually, under PMLA, there is a special provision under section 71. PMLA has also have an overriding effect on other laws, and in IBC also we have a section 238 which says IBC has an overriding effect over the other laws. When CRP starts and moratorium start, so then IBC will override the PMLA Act. Okay, when PMLA is when CRP process is not going on, so then if any activity or any action is taken by the ED under the PMLA Act, then PMLA have the overriding effect with other laws. But in case of CRP process starts and moratorium start under section 14, so then IBC have the overriding effect over the PMLA. So that is the main objective of the CRP, because because PMLA cannot impact the CRP process or proceedings. In recent years, significant number of corporate debtors undergoing corporate insolvency resolution process CRP under IBC have been found to be simultaneously subjected to investigation and attachment proceeding under PMLA on allegation of fraud, diversification of funds, origination of proceeds of crime by erstwhile promoters of management. This has resulted in complex legal overlap between the objective of the value maximization under IBC and assets confiscation under PMLA. If any assets is attached by the ED under the PMLA Act, if CRP will start, so they will have to release the corporate assets. They cannot create any hinder during the CRP process. When section 14 applies, moratorium starts. If there is any, if if ED want to take any action against the promoter and want to attach their personal property due to the crime, so they can do. But at the end of the day, they will have to release the corporate debtors. They cannot hinder and create any hurdle for the CRP process. The interaction between these two statutes raises critical issues relating to the jurisdiction, supremacy, moratorium, treatment of attached assets, and the extent of protection available to resolution professional and successful resolution applicants. It also plays additional responsibility of IP to detect, report, and manage fraudulent transaction. Actually, insolvency professional also means detect and also see whether there is any fraudulent transaction was there or not, and accordingly they also investigate at their end and check if there is such type of transaction. They also do as per the IBC code. But parallelly, if any asset attached by the under the PMLA Act, so then they can also start their continue their proceedings. But the workshop aimed to examine the evaluating justification on the interplay between the PMLA and IBC, the role of the insolvency professional in detecting of fraud during CRP, and the practical challenges faced in harmonizing insolvency resolution process with anti-money laundering enforcement in light of recent judicial pronouncements and regulatory developments. Okay, we will also discuss in detail the related landmark judgment cases. Okay, now what is the objective and what is the main aim of the PMLA and IBC? PMLA is a penal law aimed at preventing money laundering and confiscating the proceeds of crime. It empowers the ED to attach property, conduct search, seizure, and arrest. The focus is on crime. The focus is on crime-linked assets, independent of insolvency or business revival. So that is the definition, that is the objective of the Prevention of Money Laundering Act. And what is the objective and what is the definition of the IBC? IBC is an economic law for time-bound resolution of insolvency triggered by default. It provides for moratorium, resolution plan, or liquidation to maximize asset value. The objective is revival of the corporate debtor, not punishment. Okay, here that is related to the crime linked assets, or that is, and in IBC objective is to revive the business of the corporate debtor. That is not a punishment. Okay, in above cases, that is focused on the crime linked assets. So here punishment is also there. Now, prevention of money laundering. What is the objective? Objective and scope of PMLA. Statutory objective. As per the preamble of PMLA, the Act aims prevent money laundering. Okay. Provide a confiscation of proceeds of crime. Combat economic offense having cross-border implications. Fulfill India's obligation under the international conventions, UN and FTF. Nature of legislation, special crime law, focus on proceeds of crime, not merely the offense. Independent of outcome of predict offense post 2019 and judicial interpretation. What are the key definition of under the PMLA? Proceeds of crime means any property derived or obtained directly or indirectly as a result of criminal activity relating to a schedule offense. So that means that is the proceeds of crime. In includes value of such property and property outside India. If there is also a property outside India, that will also cover, and that will be means that is the proceeds of crime as per under section 21U. There is a landmark judgment, Vijay Mandal Chaudhary versus Union of India. That judgment given by the Honorable Supreme Court of India in 2022. PMLA is not a dependent on conviction under schedule offense. Proceeds of crime can exist even if trial is pending. ED can act independently. There was another landmark judgment cases, Axis Bank versus ED 2019 in Delhi with the Delhi High Court given judgment on this case. Bona fide third party interests may be protected. Bank must prove lack of knowledge of tainted property. There is another section, offense of money laundering. Okay, as per section 3. Provision, a person commits money laundering if he directly or indirectly attempts, assists, is a party to involved in any process connected with the proceeds of crime, including concealment, possession, acquisition, use or projection of untainted property. Continue offense, explanation added in 2019, money laundering is a continuing offense. Judgment given in the case of Vijay Mandal Chaudhary, section 3 covers entire life cycle of proceeds of crime. Projection as an untainted property is not a mandatory. There is another section in PMLA which says, as per section 4, if the violation of this act, so the punishment is given under this PMLA Act is rigorous imprisonment 3 to 7 years, up to 10 years for offense under NDPS Act, fine without upper limit. There is another section which attacks under the PMLA. We are discussing the major sections under the PMLA, and we will also be discussing major section and under the IBC. Attachment of property. If PMLA attached the property, section applies 5. The provision attachment for 180 days based on reason to believe property likely to be concealed, transferred or dealt with. Means the judgment Ramu Raju versus Union of India 2011, Andhra Pradesh High Court. Reasons to believe must be recorded. Attachment is preventive, okay, for the safer side, so that no person can use that property. Means if that asset, if they will not take in their custody, so then that person can transfer or sell that property unless until a title is clear. So the ED will attach and have the right to attach if they believe that assets are means transferred or concealed under the PMLA Act. Now there is another section says 8 and 6, that is the education. Educating authority confirms attachment, property retained during trial, confiscation after conviction. Also section 17, 18, 19 cover for search, seizure and arrest. Special feature given to the ED. ED officer can search, seizure and arrest. If there is a violation of PMLA Act, ED officer have power similar to police. They can arrest without warrant. Statement under section 50 is admissible. So means ED have the authority and power. They can search, they can seizure and they can arrest. They also have the power. ED officers have the power. There is a judgment. Vijay Mandal Chaudhary 2022. ED officers are not a police officers. Section 50 statements are valid evidence. Twin bail conditions upheld, then modified by the Parliament. Okay, now bail section 45 twin conditions. Court must be satisfied. Accused is not guilty. In that case, bail can be given. Will not commit offense while on bail. So these are the two conditions. If these two conditions fulfilled, so then bail can be given to that person if there is a sufficient reason to believe. For these two conditions, court must be satisfied. Accused is not guilty in a prima facie. Okay, and in case bail is given, so he will not involve and commit and continue or will not involve in that offense. Judgment Nikesh Tarachand Shah 2017. Twin conditions struck down, they revived by amendment. In another case, judgment given in the case of Vijay Mandal Chaudhary 2022. Twin conditions are constitutional. Okay, now there is another section 71, that is the overriding effect. Okay, IBC also have the overriding effect under section 238, and the same overriding power is given under this act under section 71. PMLA Act have overriding effect under section 71(1) for other acts. If PMLA Act apply, to then other act will not be in the picture. Means PMLA have the override means effect on the other inconsistent laws. So means section 71 give power under the PMLA Act to override all other inconsistent laws. So means supremacy is given to PMLA when regarding to all other inconsistent laws. But when IBC will come into the picture, so then IBC will override override all the inconsistent laws, including PMLA, because corporate debtor assets will have to release by the ED department to the insolvency professional. Now, we have discussed what was the overview, what was the objective, what are the related sections under the PMLA. Now, in shortcut, we will also go through the major section objective under the IBC code. What is the objective scheme of IBC? This is a statutory objective. First objective is time-bound resolution of insolvency, as we know. The another main objective is maximization of value of assets, balance interest of stakeholder, promote entrepreneurship and credit availability. That is the main statutory objective of the IBC code. Okay, our first objective is to survive the business during CIRP. If survival is not possible, and so then company will have to go to the liquidation. But during CIRP, our approach will be going concern approach. Okay, because going concern approach means कि we believe कि business will continue. Okay, if CIRP fails, so then company will go into the liquidation. Then we will have to sell the assets. Then, after selling the assets, the distribution to all the stakeholders will be given under section 53 as per waterfall mechanism. So these are the process. There is a first phase is CIRP. If CIRP fails, then company will go to the liquidation. Okay. Now when CIRP starts, when moratorium starts as per section 14, if there is any corporate debtors, any assets attached by the ED, okay, so then these assets will have to release by the ED. They will not be able to attach the corporate debtors, because what will happen if they will not release the asset? CIRP is a time-bound process. So then insolvency professional and will not be able to complete this CIRP within time period, and the statutory objective is time-bound. So that's why it's statutory, it's mandatory. ED will have to release the corporate data assets, they cannot create or any create any hindrance for the CIRP process. Nature of law, economic and commercial legislation. The objective of this IBC code is not a punitive but resolution oriented, because when CRP starts, our objective is to survive the business. Then we are not giving any punishment. We are not taking any legal action. As per this act, not any legal action is taken. Means for as a punitive, because when company will go into the CRP process, then IRP and RP will be come into the picture. So they will do their best to survive the business. So means the objective is to survive the business, not a punitive. That is the nature of law. Okay, statutory objective we have discussed. Number one is time bound, maximization valuation assets, balance interest of stakeholders, promoter intervention and credibility. This is the statutory objective. Now, what is the core provision with judgment? As you know, 7, 9, 10, section financial character, section 7, operational character 9, corporate data 10. So these are the section attacks. These are the means section. If any stakeholder want to submit, take any action against the corporate data, financial character also can submit their petition under section 7, operational character under section 9, and corporate data itself can also submit their petition under section 10. Now, judgment, innovative industries versus ICICI Bank. IBC has overriding effect under section 238. As we have already discussed, PMLA have the power under section 71 and IBC have power under section 238 overriding effect. When with all the inconsistent laws, IBC has overriding effect under section 238. Once default is proved, admission is mandatory. Then what will happen? Then moratorium start under section 14. So what will happen? Institutional suits, execution proceedings, transfer of assets, aim to preserve corporate debtor as a going concern. The related judgment is P. Mohanraj, Shah Brothers 2021, Section 138, Negotiable Instrument Act proceedings covered under moratorium. Means when moratorium will start, so then no further proceeding or no further legal action can be taken by the any stakeholders. Okay, and existing proceedings will stop. Okay, means because otherwise what will happen if proceeding is going on and new cases will be filed by the stakeholders or other parties, so then insolvency special will have to face the legal issues. He will involve very much in the to resolve the legal things. So then he will not be able to concentrate on CRP process. So that's why all the legal proceedings will stop and no further new legal case can be filed when moratorium will start under section 14 during CRP process. So that is the main objective of this code. Now, management by IRP, RP, section 1718, powers of board of directors suspended. RP takes control of assets and operations. Insolvency states, section 36, if CRP will fail, then company have to go to in the liquidation. Section 36 includes all assets of corporate debtors, excludes third party assets. Resolution plan, section 30 says must provide payment of CRP costs, compliance with laws, fair treatment of stakeholders. Judgment is Committee of Characters of SR Steels versus Tish Kumar Gupta 2019. Commercial wisdom of COC is supreme. Means, as we know, all the commercial wisdom decisions only can be taken by the COC. Insolvency professional is only the facilitator. Okay. For example, if any resolution plan is submitted by the resolution applicant, okay, he can go through the detail. If everything is okay, is consistent with and fulfill the objective of the IBC. Okay, so means, and if not against the IBC code or IBC law, so then the resolution plan will be reviewed by the COC. First approval resolution plan will be approved by the COC and then by the adjudicating authority. Means insolvency professional cannot take commercial vigilance decision. Only commercial vigilance decisions can be taken by the COC, and COC is having the supreme authority because all the financial characters okay, are only the member of the COC. They can take the commercial wisdom decisions. I'm again telling, as you know, कि insolvency profession is only a facilitator. NCLT NCLAT cannot interfere except for limited grounds. Once a resolution plan is approved by the COC, NCLT or NCLAT means educating authority also, and don't interfere. They only see whether these are the as per the IBC code. Means this is inconsistent with the IBC laws. Okay, though they will not go into the means commercially. They will not interfere. Okay, they will only see legal in the legalities means is there as per IBC code or not. If resolution plan fulfills all the legality and consistent with the IBC code, so they will approve. Okay, so they will not interfere in this. Approval of resolution plan. Then Section 31 applies. Approval plan is binding on the central and state government, statutory authority and characters. Once resolution plan is approved by the COC and by the adjudicating authority, then they have the binding effect on the state, central, statutory, character. All the stakeholders will be bind as per the resolution plan approved. And after approval of the resolution plan, if any claim is submitted by the any means stakeholders or any means characters, so that will not be admissible. If resolution plan is approved, okay, so then no claim will be accepted in any circumstances, whether it is submitted by the state government or central government or any statutory authorities. The related judgment is Ghanshyam Mishra versus Edulus ARC 2021. All claims not part of resolution plan stand extinguished. Okay, means, for example, as we know that is a time-bound process. CRP need to complete within 180 days plus 30 plus 30. Extension period is also can be taken. But if any authority, for example, if there is an assessment, if any authority taking time and not submitting their claim as per the IBC code or on or before time, so that is their mistake. So due to this mistake, if resolution plan is means if they have taken very much time, a resolution plan already approved by the COC and adjudicating authority, and if statutory authority, say for example income tax authority come and submit their claim, or in fact or PF or ESI, any statutory authority or state government dues or statutory dues, if claim submitted after the approval of the resolution plan by COC or adjudicating authority, will not be entertained. Okay, because resolution plan will be bind on all the stakeholders. Okay, now when resolution plan is submitted by the resolution applicant, okay, that approval is given. Okay, now if claim is given, so then why they will suffer? Okay, because for example the resolution plan submitted by them for 500 crore, okay, on the basis of the business or on the claim that is approved by the COC and adjudicating authority, and all of a sudden claim is submitted by the statutory authority, say 200 crore. Okay, so then they are not means liable to pay to entertain, because after approving that, because they was supposed to submit their claim on or before that as per timeline given by the CRP or as per the IBC code. So means that is very important and landmark judgment Ghanshyam Mishra Edulus ARC. All claims not part of resolution plan stand extinguished. Fresh slate principle applies. Okay, so that is also very important. Means when resolution plan is applicable to all the stakeholders, then they will start their business from without liability. Means the clean slate status will be given to the new resolution applicant, because who will take over the business, so they will not liable for the previous means liability or any act. Okay, so they will start their business from clean, will fresh start. So that is called the clean state. Now, if CRP fails, then company will go into the liquidation. Then section 33 and 53 will apply. Triggered if CRP fails. Waterfall mechanism under section 53, as we have discussed. If CRP fails, then company will go into the liquidation. Then liquidator will sell the corporate debtors assets. Okay, and as per priority given under the waterfall mechanism, as per section 53, there is a priority wise payment. Okay, for secured debtor, means CRP and liquidation costs for unsecured statutory. So there is a priority given as per section under waterfall mechanism under section 53. According to the waterfall mechanism, section 53, the sale of the proceeds of the corporate debtor assets will be done as per the section 53, as per the waterfall mechanism. So that is also very important. And also, if any asset is attached by the ED, if ED will not read that asset, so then liquidator will not be able to sell that asset. So that is mandatory as per the IBC code. ED will have to read that assets, and that assets will be sold by the liquidator, and the proceeds of the sale of that assets will be distributed as per the section 53, as per the waterfall mechanism. So that's why when PMLA and IBC both will come during the CRP process, then IBC have the override authority in case of inconsistent laws, including PMLA. Now, overview of PMLA and IBC legal framework. Avoidance transaction section 43 to 51 and 66, preferential, undervalued, external fraudulent trading. Now, Arun Jain, there is a landmark judgment, Anuj Jain versus Axis Bank. Mortgages created for group companies can be avoided. Okay, so that can be avoided. Okay, now overriding effect, section 230, IBC prevail over inconsistent laws. Now, key comparative principle from judgments. Principle PMLA IBC. Nature of law. Nature of law under PMLA, that is a panel and conflict secretary. Means in this assets is attached and there is a punishment, there is a legal action, means penalty and imprisonment is there. So means that is a based on the panel and conflict secretary. IBC is the economic and resolution center, because IBC objective is to resolve the issue and survive the business. Okay, so that is not the IBC is not a punitive. Now, trigger. When PMLA will trigger, when any crime will happen, proceeds of crime means money laundering, anti-money laundering. So these are the crime if happens. So then PMLA will trigger, and IBC will trigger when there is any default, any financial default. Then under section 7, financial creditor can submit their petition. Okay, if corporate debtor don't pay the loan taken from the financial creditor, which must be over 1 crore. So there is a limit. If means that loan must be more than 1 crore. Means if there is a default, so then IBC will trigger. Now, what is the objective here under the PMLA? That is a crime prevention. Okay, so the objective is crime prevention, to avoid crime prevention. Okay, if the crime is ongoing, so then need to prevent and then need to take further action to stop that crime. So that is the objective of the PMLA. And for IBC, objective is to maximization value of the assets. And here under the PMLA, section 75(1) have the override effect in case of inconsistent with other laws, and IBC section 238 have the override impact with inconsistency of laws. Okay. Now, one thing more, means during CRP, IBC prevails once CRP is admitted. Section 14 moratorium applies. ED cannot attach or continue attachment of assets of the corporate debtor. IBC overrides PMLA during CRP, that we have discussed. In this case, we have also faced another landmark judgment cases. Our Directorate of Enforcement versus Manoj Kumar Agarwal. and others ancillate held the PMLA attachment cannot frustrate CRP. Okay, means there was another landmark judgment given by the ancillate. Okay, means if there is a attachment by PMLA held that PMLA attachment cannot frustrate CRP, means if ED will have to release that assets. They cannot frustrate CRP. Okay. And another thing also, we will also now cover the another point, interplay between PMLA and IBC, but I will also elaborate some points. Means in case after resolution plan approval, IBC clearly override PMLA. Section 32A of IBC provides completely immunity to corporate debtor assets covered under the resolution plan. It cannot proceed against the corporate debtor or its assets. Okay, see, there is another one very important point. Prosecution may continue only against erstwhile promoter management. If there is a crime or any illegal activity done by the promoters or management, the prosecution may continue. Okay, only against erstwhile promoters or management, but they will have to release the corporate debtor assets. They cannot attach the corporate debtors when moratorium under section 40 will start. Okay, means there is there was another also case I remember, Manish Kumar versus Union of India, Supreme Court in 2021. There was a judgment given upheld constitutional validity of section 32 and gave primacy to IBC. In that case, the judgment, the supremacy was given to the IBC. Okay. And another point we have covered during liquidation, conditional override, assets forming part of liquidation estates as per section 36, IBC prevails, ED attachment must give way. Personal assets of promoter directors, PMLA continues. There was also a judgment, of JSW Steel Limited versus Mahinder Kumar, ED enclate. They says where PMLA still prevails, receipts of crime not forming part of insolvency, instead personal prosecution and attachment of promoters director KMP. Okay, offense committed outside the scope of the resolution plan. So means if there is a PMLA can take action against and continue against the promoter, management, KMP persons if they are personally liable for any crime. Okay, but corporate assets will have to release for the purpose of the complete of CRP. Now, how they interplay between PMLA and IBC? See, attachment of assets during CRP liquidation. Okay, we will discuss. In shortcut, we have discussed, but in detail, we will discuss. See, there is a legal issue. Whether the enforcement director can attach assets of a corporate debtor under PMLA when CRP is going on or liquidation has commenced under IBC. Okay, there is a statutory provision involved, section 5, 8, 70, 71 we have already discussed. They have the overriding impact, and also section 238 have also the overriding if means effect. Okay, now section 5 says provisional attachment of property. ED may provisionally attach property for 180 days as per section 5 based on reason to believe that property is proceeds of crime, prevents transfer or disposal. Okay, so as per section 5. Okay. Now, there is a landmark judgment cases, Rama Raju, Union of India, 2011, AP, Andhra Pradesh High Court, Honorable Andhra Pradesh High Court. Attachment is preventive. Okay, because they do they do attachment so that assets can be protected. Okay, and given to the right person. Who is the person? If that asset is earned through the anti-money laundering, so then PMLA will come into the picture, and then legal action means there is a penalty, and also imprisonment will also attract under the PMLA. But attachment is preventive, not punitive. Reason to believe must be recorded. There is another case, Varsana Ispat Limited versus Deputy Director, ED 2018 enclave. attachment of corporate debtor assets cannot affect CIRP. This thing we have already discussed. Okay, means, and in this case also attachment is preventive, not punitive. Reason to believe must be recorded. Okay, if that is the case. In another case, that is also landmark judgment. Attachment of corporate debtor assets cannot affect CIRP. Means ED will have to release the assets if they have already attached. Otherwise, CIRP will not be able to complete within time frame as per the IBC code. Okay, so means attachment by ED of the of corporate assets, if there is attachment, they will have to release. They will not create any hinder. They will not obstruct this CIRP process. If application is accepted and moratorium starts under section 14. Okay, now IBC relevance attachment during CIRP defeats value maximization and resolution. So that is also a very important. If they will attach, so then what will happen? It will take time to release the assets. So then that assets will destroy, and the value of maybe will be reduced. Okay, because it will take time, and due to there is a technology change due to any reason, so the value of the assets will reduce. Okay, and also another factor is insolvency professional will not be able to complete their CIRP process as per the time bound period, which is the statutory objective of the IBC code. So that is a very, very important critical point. So that is the reason from IBC relevance point of view, attachment during CIRP is not practically possible and also not statutory possible, because IBC code is a code, not an act, and IBC code have the overriding effect in case of inconsistent of laws, inconsistent of other laws. Now coming to the section 8, education and confiscation provision. Educating authority confirms attachment. Property remains attached during trial. Okay, means education confiscation. What are the provisions? Educating authority confirms attachment. Property remains attached during trial. Okay, when there is a trial period is going in the in the court, so then property will remain attached. Confiscation only after conviction. Okay, now there is a landmark case, Vijay Mandal Chaudhary, Union of India. PMLA proceedings are independent of conviction, but confiscation require due process. Okay. Now, this was another landmark of JSW Steel Limited versus Mahindra Kumar Khandelwal Bhushan Power 2021 Enclate. After approval of resolution plan, confiscation against corporate debtor is impermissible. Now, Section 71's overriding effect, PMLA override inconsistent laws. There is a landmark judgment, Solidaire India Limited versus Fair Growth Financial Services Limited in year 2001. The judgment given by the Supreme Court of India. Latter special law prevails over earlier law. So that is the power of the PMLA. In case of inconsistency of any law, PMLA will have the supremacy and override all the inconsistent laws except IBC. Okay. Now, Vijay Mandal Chaudhary, 202 Supreme Court, PMLA is a special criminal law. Okay, but must be harmonized with other special statutes. Okay, means it's very obedient and very clear. PMLA is a special criminal law, because there is a, when any criminal activity is done, anti-money laundering is done. Okay, so then PMLA apply. So then PMLA is a criminal law. Okay, but at the same time, that PMLA is to be harmonized, means with other special statutes like IBC code. Okay, so they will have to make the means consistency with another laws. Now IBC section with landmark judgments. Section 40 says moratorium provisions prohibit suits recovery. Okay, means when section 40 will apply, so then what will happen? That will prohibit suits. Okay, no stakeholder, no outside party will be able to take submit the case and take legal action, they can submit their claim. Okay, if why another party, another person will take just 1 minute. Okay. See, why another stakeholder or another party want to take legal action? Because they want to recover the money. Okay. But as per IBC code, if they want to recover their money, they can submit their claim. Means they will, any person or any authority will not, or any stakeholder will not allow to take legal action further when moratorium starts. The purpose is this, ki otherwise we will not be able to complete the CRP process in time bound period, and that was this statutory means objective of this code, because we are to complete this process in time bound period, value by maximization, and interest of the all the stakeholders. So these are the main primary statutory objective. So that's why when moratorium start as under section 14, no means that will prohibit suits, further suits, recovery. Okay, so means no recovery can be done. Means for example, if in case if GST department or custom department, okay, if want to take further action, if they have means any goods, anything in their custody, they want to recover, so they will not be allowed. Okay, means the section 14 moratorium will prohibit suits, recovery. Okay, no recovery can be done by any authority, enforcement and transfer of assets. Okay, because if these things will happen, then what will happen? If then insolvency profession will not be able to survive the business, because the first main objective is to survive the business on the basis of going concern approach. During CRP process, insolvency professional means work on the going concern approach, because our objective is to run the business, to survive the business. If business will run, business will work, so then what will happen means all the stakeholders, if any authority want to recover their money, when business will start, business will continue, business will survive, so then easily means company will be able to means pay all the claims, and can also be paid any due amount. Okay, so that's why for that purpose it's mandatory, and it is also in the interest of the business as per section 14, which will provide suits, recovery, enforcement and transfer of assets applied during CRP. That is very, very important and critical from the CRP process point of view. That is very, very important. Without moratorium, CRP process is not practically possible. Okay. Otherwise, what will happen? Insolvency professional will have to face means more concentrate, more focus on all the to resolve the legal issues. So then resolution professional will not be able to focus on the means reviving of the business, survival of the business. So there is a landmark judgment cases P. Mohan Raj versus Shah brothers. Moratorium covers all proceedings having civil consequences. Okay. Varanasi Ispat Limited 201 Enclate. PMLA attachment against corporate debtor is hit by moratorium. Okay, PMLA attachment against corporate debtor is hit by moratorium. Means because when moratorium will start, PMLA will have to release the assets to the corporate debtor. So that means moratorium hit to the PMLA Act. So that is means the judgment given by the Enclate in 2019 in the case of Varsana Ispat Limited. Now, what should be the duty of the IRP or IRP when any corporate debtor assets is in the custody of the ED? So, what should be the duty of the IRP or RP? IRP must take control and first duty is this कि IRP or RP will take and control of custody of all the assets. Corporate debtor to be kept as a going concern. This thing we have already discussed. Unless until they will take the custody of all the assets, because they at least then they should know what are the assets of the company, of the corporate debtor. Okay, if that physically means there or not, they also need to verify these assets, because sometimes what happens, assets are in the books but physically not in the not available. So these means insolvency professional or IRP need to take first control and custody of all the assets and verify with the books of accounts if there is any asset not updated in books of accounts in asset register, so then need to update. Otherwise, if physically not available, so then need to know why physically not available. If that asset is sold, not updated in the asset register, so means corrective action need to taken by the IRP or RP. There is a landmark judgment case in Swiss Ribbons versus Union of India. IRP RP is central to value preservation and resolution, because first they will preserve the assets, they will take the custody control of the assets, then they will resolve the issues which is coming in the business for the purpose of reviving the business or survive the business. Okay, so means IRP RP is a central to value preservation and resolution. Okay, now section 32A, that section is also very important. Section 32A give immunity to corporate debtor and resolution applicant provisions. Corporate debtor not liable, okay, for past offences after plan approval. If the resolution plan is submitted by the resolution applicant and resolution applicant have taken over the control of the management, so then they will start the business as a clean slate. They will not be liable for their past offences or any liability or any means they will not be responsible for any means liability for any crime or any offense. Okay, these section give 32 the immunity, means also give the protection to the resolution applicant, promoters या past management excluded. Okay, the landmark judgment case related to this section 32A, Manish Kumar versus Union of India 2021 Supreme Court. Section 32 is constitutional and essential for IB's success, because if I have submitted the resolution plan, I am a new resolution applicant, I have taken over the business. Okay, so then I should start that business from clean state now, because I will what I will do, I will settle all the claims. Okay, mean I will start the business from clean state, means I will not be responsible for other previous act or previous wrong things, because section 32 says कि previous things are zero when resolution plan is submitted and taken over the management by the new resolution applicant. So then for previous things, new management will not be responsible. So this section gives the immunity to the new corporate debtor. In new corporate debtor, previous promoter debtor are excluded. There is another landmark judgment case, JSW Steel, Bhushan Power case. ED cannot continue attachment post resolution. Okay. So this is but obvious. For example, if CRP is completed, okay, if if CRP fails, then company will go to the liquidation. I'm saying if company is not going to the liquidation, if company is in the process CRP, okay, and if resolution plan is submitted, everything is okay. Now ED cannot continue attachment post resolution, okay, because that will also give the means immunity to under the section 32A, because if resolution is already done, Okay, so then if new management will not be responsible for previous act, so that's why clean slate will be given to the new promoters or the resolution applicant. Okay, so that is very, very critical and important point here. So actually, when we face any new challenge, so then we have to refer the landmark judgment cases. In case if these are landmark judgment cases are available, some of the judgment are also inconsistent. As you know, rainbow case. Okay, so means but there is a one or two cases are inconsistent, but normally we have to refer the landmark judgment cases which give us light how to resolve to these type of issues when come in the business. Okay, in case if there is a new issue, so then definitely we will have to means go approach to the adjudicating authority. But if there is a already landmark judgment is are there, when you will refer with the court, then you can get the better and means early resolution of that issue. Okay, now coming to the section 36, insolvency state liquidation provisions. All states of corporate debtor from liquidation state. There is a landmark judgment in Persona Ispat Limited. ED attachment cannot exclude assets from insolvency state. There is a section 230 says overriding effect of IBC. IBC override inconsistent laws. This we have already discussed. That is very, very important. There is a landmark judgment, Innovative Industries versus ICICI Bank 2018 Supreme Court. IBC has overriding effect over all other laws. There was another very, very important landmark judgment was this one. This one. Okay. Approved resolution plan binds all authorities, including government. See, this we have also earlier discussed. Means why that is important. Why this is important? This is important when resolution plan is approved by the adjudicating authority. If all of a sudden government authority or statutory authority is coming and submitting their claim, okay, so that claim will not be entered and that claim will be rejected by the resolution professional, and also will be not approved or rejected by the adjudicating authority. Once resolution plan is approved by the adjudicating authority, that means that was a mistake of that stakeholder who didn't submit their claim as per the IBC code in time bound period. Because if they will not submit their claim in time period, so that is their mistake. Otherwise, what will happen in case claim will come means on regular basis, not as per the IBC code timeline period, so then resolution will not be possible in time as per this code. So that IBC Act was came into the picture because the intention was to means do the resolution within a time frame period. In earlier act was what was happening. There was also another act was there. Okay, so in those act was taking very much time. If in case if it will take 3 years, 4 years, so then what will happen if there is any factory? If the machines are there, if resolution process will take 3 or 4 years, then what will happen? That machine will not work. Number two, maybe due to the time gap, there may be a technology change. There may be a means change of government policy. There may be a change in demand. Okay, there are so many means factor which will means hit. Then the value of the machinery will means erode very drastically, and the resolution must be in a short period so that company can survive. And if there is a short period, then you can take means appropriate step. Either you can survive, otherwise you can sell those assets at the maximum value. if you will sell the assets at maximum value, so then you can distribute the sale proceeds to the all the claimant. Okay, so that is the objective and that is the reason. Okay, so this point is also very important. Sometimes this is a very landmark judgment case, because government department are submitting their claim on time. For example, if income tax authority came and says ki it takes time to do the assessment, okay, and not submit their claim as per the time period. Okay, so that is very big challenge. Okay, practically that was a very big challenge was facing by the professionals, resolution professionals. Okay, so but with the help of these landmark judgment cases gives us the power and have the confidence to take the right and correct decision by the resolution professionals, and also educating authority can also means refer these type of landmark judgment cases to resolve these type of issues. Now coming to the judicial position, Varsana Ispat Limited, Deputy Director ED 2019 Inclate. Assets attached under PMLA cannot defeat CIRP, that we have already discussed. Corporate debtor assets must be available for resolution. This thing we also discussed. It is required to release attachment to enable resolution. So that is very important. That is also a landmark judgment case. Means assets attached under PMLA cannot defeat CIRP. That means PMLA will have to release the assets. Okay, when moratorium as per section 14 starts, so PMLA ED department will have to release the assets. Okay, for the purpose of CIRP, they cannot obstruct the CIRP process. Another one is corporate debtor assets must be available for resolution. If assets will not be given to the transfer or give release, so then resolution process will not be possible as per the IBC code. And IBC code as per section 238 have the override effect impact in case of inconsistent of other laws. It is required to release attachment to enable resolution. So that is very important and critical points. And this is judgment is also a landmark judgment is also very important from this point of view. There is another case, Directorate of Enforcement, Manoj Kumar Agarwal, Ruchi Soya 2022. Once CRP is initiated, attachment of corporate debtor assets frustrates IBC objectives. Okay, resolution process has priority over attachment. Okay, means in this judgment also given clear cut way. Once CRP is initiated, moratorium starts, section 14, attachment of corporate debtor assets. If not released, then IBC objective will not be cannot be achieved. Okay. For resolution process has priority of attachment, means for the purpose of resolution is have the more priority over the attachment. Means here it means IBC have the authority or power or override in case of inconsistent law of PMLA when CIRP starts under section 14. Okay, so that is this is also very important landmark judgment. Okay, now coming to JSW Steel versus Mahindra Kumar, Khandelwal, Bhushan Power 2021 and Clate. After approval of resolution plan, okay, ED cannot continue attachment against corporate debtor. Okay, after approval means if any resolution plan is approved, okay, so ED cannot continue attachment against corporate debtor. Okay, PML action can continue against promoter, not the company. Okay, means if promoter have done any crime, any anti-money laundering, action can continue by ED under the PML Act against the promoter, director, can be persons, but not the company, because company is in CRP pro. So then section 14 moratorium will start. So then company will be in the resolution process phase as per the IBC code. Okay. So no further action can be taken against the corporate or company, because the wrong thing done by the promoter or company itself doesn't do anything. If any crime, any wrong thing done by the promoter, management, or KMP, the action may continue against those culprit persons under the PMLA Act by the ED. So that is very, very obedient. Okay. So these are the landmark judgment. These are the very important. Okay. Now, legal principles. Assets of the corporate debtor forming part of insolvency estate cannot be kept under PMLA attachment if it obstructs CRP or liquidation. So that is the very important point. Okay. Means when PMLA and IBC both will come into the picture, IBC have the override effect with all the inconsistent laws, including PMLA. That is the moral, or that is the moral of the story. IBC is having the supremacy, having the more authority, having the more power than any other act, including PMLA, because government's objective is to survive the business. Okay, if it's fail CRP, then company will give the liquidation. But for that purpose, ED will have to release the corporate data assets. PMLA can continue action in case of any crime, any anti-money laundering, any other crime related under the PMLA. Then ED can continue their proceeding against the corporate debtor, promoter, or any other person, including KMP. Okay, but in this note, new resolution applicant or new promoter management will not will be involved in this when they have already submitted resolution plan, and that is also approved by the COC and the adjudicating authority. So then they will start the business with clean state. Okay. Now, what moratorium under section 14 of IBC versus PMLA proceeding, legal issue. Whether PMLA proceeding, attachment, education, confiscation are barred by the moratorium under section 14. This we have already discussed. Leave-in provision. Section 14 IBC moratorium will start. So section 5 and 8 PMLA attachment and confiscation. Okay. So these are the leave-in sections. When IBC code CIRP process start under section 14, moratorium starts. Okay. So then if section 5, 8, 5 and 8 of PMLA attachment confiscation will continue, note that this thing, judicial interpretation P. Mohan Raj versus Shah Brothers 2021, judgment given by the Honorable Supreme Court. Moratorium applies to all proceedings having civil consequences. Okay, means for civil consequences, no further civil legal action can be further taken, or if there is cases are going on, that will stop. So means purpose is to maintain corporate debtor as a going concern. So this is the objective. Okay, but if there is a criminal activity things done by the promoters, by the management KMP, so these proceedings can be continue under the PMLA Act by the ED. See, personalized path limited. PMLA attachment proceedings are covered under moratorium. ED action during CRPs, ED actions during CRPs are state. Now, Deputy Director, ED versus Axis Bank 2019. 2019 Delhi High Court. Moratorium protects corporate debtors, not individuals. Okay, this we have discussed. Moratorium protects means corporate. Who is the corporate? Corporate debtor means company. Okay, means if there is a corporate debtor assets are there, so these will have to release. But if any wrong thing done by the director promoter, so it doesn't mean the CRP process starts, so they will means they are also safe. No, if they have done any criminal things wrong under the PMLA, the action can be taken and continue by the ED. It doesn't mean if CRP process starts and section 14 means to start, moratorium start, they will not protect to the individual if they have done something wrong. Something wrong means if they have done anti-money laundering or done any crime, okay, so they will not protect it, okay, under the section 14. Section 14 only protects to the company to stop or to prevent for further legal cases against the company for the purpose of continue the CRP process, but they will not means give any protection to the individuals. PMLA proceedings can continue against promoter and actors. Okay, that this is very very important. That judgment is very very means critical and important from the means interplay between PMLA IBC. Position summarized against corporate debtor. Moratorium applies. See, this we have already discussed. Against promoters or accused individuals, PMLA continues. So this is very very important. Okay, means against corporate debtor, moratorium will apply. Section 14 will apply. Against promoter accused individual, PMLA act or means may or can continue if ED think there is need to take action because they have done the violation of the PMLA Act, so they may means take further action or proceeding on the basis of evidence or on the basis of supporting which they have. Okay, but this moratorium will not protect to the promoters and individuals. So that is very clear cut. Moratorium will protect only to the corporate, to the company, not to the individual or promoters. Now, question coming in priority and supremacy, ED versus resolution. This we have discussed. Section 71 PMLA overriding effect. Okay, 230 also having the overriding effect. 71 says as per PMLA, in case of inconsistent with other laws, then PMLA have the overriding effect. But and in the similar section 238 also says IBC have the overriding impact in case of inconsistent of other laws, but it's also including PMLA because there is a difference between act and code. The other legal are act, but IBC is a code, and code have the supremacy over all the other inconsistent laws, including PMLA. The judicial resolution. Just a minute. Okay. Judicial resolution. Solidaire India Limited versus Fair Growth Financial Services 2001. Okay. Supreme Court. Later special law prevails over earlier law. Innovative Industries versus ICICI Bank 2018. Supreme Court says IBC has overriding effect over all inconsistent laws. Okay. As per section 238, which we have already discussed. Okay. Vijay Mandal Chaudhary. PML is a special criminal law. Okay. Vijay Mandal Chaudhary versus Union of India 2022. Judgment given by the Honorable Supreme Court clearly says at state PMLA is a special criminal law. Okay. IBC is not a criminal law that focus on the resolution. So that is the difference. In PMLA is a focus on the criminal law, and IBC focus on the resolution process. However, does override economic resolution under IBC means the objective is also clear. That focus on the criminal law in case of any violation of that act, attack to the criminal law. Okay, and this in case of any default is there, so then IBC code will focus on the resolution process. So that is the clearly stated in this landmark judgment. Harmonized principle. IBC prevails where attachment under PMLA obstructs insolvency resolution process, but PMLA prevails for penal action against offenders. So that is also very important. The harmonized principle means IBC prevails where attachment under PMLA obstructs insolvency resolution, but PMLA prevails for penal action. Penal action means against the individual promoter, director, if they have done any crime. So means legal action will continue against those individuals. Okay, but after section 14 moratorium starts, so then no means attachment or no other any legal action will be taken by the ED under the PMLA Act for corporate debtors. Now, okay, now coming, what will be the impact on the resolution applicant and COC? There is statutory protection. We are discussing about short. Section 32A give the means immunity to the resolution applicant who submit the resolution plan, because after submitting the resolution plan and approved by the adjudicating authority, they can start their business with clean state. So means they will not be responsible for previous act done by the management, promoter or directors. So these are the section 32A gives the immunity to the new resolution applicant, promoter or director. So that is very, very important section from a resolution point of view. Okay, in respect to PMLA. Okay, because PMLA also means include under section 32A, because if there is an inconsistency of law, means that it means when section 32A apply, so means PMLA also means included in this. Means this section have the supremacy. Introduced in 2020, protect corporate data resolution applicant, ensure clean state and certainty in a resolution. Key provision of section 32A. Corporate debtor not liable for offense committed prior to CRP. Okay. Protection applies once resolution plan is approved. Doesn't protect promoters or person in control earlier. So that is very, 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 very important. We need to okay. There is a landmark judgment case, Manish Kumar versus Union of India. Section 32 is a constitutional. Encourages genuine resolution applicants, essential for successful of IBC. The related landmark judgment cases related to this section, which covers Ghanshyam Mishra versus Edulus ARC, Asset Restructuring Company, 201, judgment given by the Supreme Court. All past claims and liabilities stand extinguished, means will not be applicable to the new promoter, new director, new KMP, means resolution applicant who submit the resolution plan. When they will take over, they will take over the management, they will take over the business. They will not be responsible for any past claim and liability, and all the past claim and liabilities will stand extinguished. They have the clean state principle upheld. That will give the immunity to the new resolution applicants. There is another landmark judgment case, JSW Steel, Bhushan Power case. ED cannot attach asset. Okay. After resolution plan approval. Okay. If plan is approved, and then that resolution plan will be bind upon all the stakeholders as per IBC code, including central government, state government, statutory authority. Okay. So when that resolution plan will be bind upon all the stakeholders. Okay. So means, so then it's also included in the statutory authorities. Okay. So that also includes ED and PMLA Act also included, means after resolution approval, which will bind upon all the stakeholders, then after approval, ED will not be able to attach the assets. It doesn't mean if CRP process is going on, ED release the assets. If CRP process is completed, means resolution plan is submitted and taken over by the new management, and ED is coming and attaching the asset. That is not possible because as per section 32A give the immunity, all the previous things will be extinguished related to the all past claim and liabilities. So means ED will not be able to attach these assets again, okay, or after the resolution plan approved. So that is very, very, very important and critical and important in case of PMLA is there and IBC is there. So that is very, very important. Okay. As a professional, we also need to remember or know कि ED cannot attach any corporate data assets during CRP, or if they have already attached, so they will have to release the assets when moratorium starts, section 14. In case if resolution plan is approved and that will bind, although ED will not be able to attach the assets also after the resolution plan approved. Okay. Okay, impact on COC. Ensure certainty in valuation. Okay. ED cannot attach assets after resolution. Okay, now impact on COC. Ensure certainty in valuation, prevents value erosion due to attachments, encourages competitive binding. Means what happens in impact on COC? Ensure certainty in valuation. Okay. Prevent value erosion due to attachments. If ED will take time and release assets and ED will not release the assets in time, so then what will happen? The value of the assets will erode, and the statutory objective is to complete the process, resolution process in time bound period, also with the maximization value of the assets need to be recovered. So if attachment is there, so then it will impact, and if we want to do the maximization of the value of the asset, then we need to prevent value erosion due to attachments, encourage competitive bindings. Okay. Now, interplay between PMLA and IBC, consolidated legal positions, judicial consequences. Now, there is the issue, judicial outcome. Attachment during CRP, that is issue. Another is moratorium versus PMLA. Third is ED versus IBC. Fourth is resolution applicant. Fourth is promoter. Okay, now issue. What will be judicial outcome? Attachment during CRP not permissible if it hampers resolution. Okay, so that is clear cut. Ki during CRP ED cannot attach asset. Okay, and also after approving the resolution plan, also ED cannot attach the asset. When moratorium start versus PMLA, moratorium applies to corporate debtor. Okay, in that case, what will happen if moratorium start? No stakeholder or no other person can take any further legal action. They can only submit the claim. ED versus IBC, EBC prevails for resolution, but ED and PMLA focus on the crime. Okay, if crime happens, so then ED will come into the picture as per PMLA Act, and IBC is based on the resolution process. Resolution applicant fully protected. Okay, under section 32A. Okay, promoters, PMLA continues against them. Okay, means this thing we already discussed. Resolution applicant under section 32 give immunity to the new resolution applicant. Okay, so they will start their business with clean state, and in case if there is something done wrong by promoter, director, okay, or KMP, done any crime, so then PMLA may continue by the ED. Okay, So that will not give the protection. If Section 14 moratorium start, they will give only the protection to the corporate debtor, not to the individual. Okay. 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 Now further we will discuss role of IRP and RB. We can take 5 to 10 minutes break if you want. You want to take break for 10 minutes?
Yes, that will
Yes,
be
sir.
very helpful.
Okay.
Yes, sir.
Okay.
We would
Okay,
like
we
to
will
have.
take 10 minutes break. Okay.
Then we shall be back by 3:40.
Yes, 3:40 we will continue. We will take 10 minutes break. Okay.
Okay.
Okay, let's start. Can we start?
Yes, sir.
Yes,
Yes,
sir.
sir.
Okay.
Start, please.
Okay. Now we will cover what should be the role of IRP RP liquidator in detection of fraud under IBC 2016. Someone is unmute. I will request you to mute, please. Okay. Now there is a statutory position of IRP RP and liquidator. IRP RP and liquidator are officer of the court and fiduciary of all stakeholders. They are not administrators but statutory investigators entrusted with uncovering fraud, misfeasance, and asset diversion. The Supreme Court in Swiss Ribbon Private Limited and Union of India case held that the resolution professional is a key pillar of the insolvency framework entrusted with the duties to preserve assets, examine past conduct, because as we know, we have to see there is a means if a wrong transaction happened, so then we have also to past and verify the past transactions within 6 months or within 1 year as per the IBC code and ensure the integrity of the CIRP. What is the statutory duties of IRP regulator relevant to fraud detection? What are the duties? Section 18 says collect financial information, take control of assets, view, verify past records. Okay, now Section 25 says RP preserve assets value, appointment, forensic auditor if and detect avoidance transactions. Section 35 says liquidator investigate financial affairs, report fraud, pursue recovery. So these are the role and duties or main role of the RP. Now there is a judicial landmark judgments related to this. Judicial interpretation of Section 18, 25 and 35 says Asral Mittal private case versus Tishkar Gupta 2018. The Supreme Court emphasized that RP must examine the conduct of promoters and related parties to determine whether the transactions were designated to defeat creditors' interest. Okay, so this thing was observed and given in the judgment. Now there was another landmark case, State Bank of India versus Maintainer Limited by Anclate. The appellate tribunal says failure of the RP to examine suspicious transaction may amount to deregulation of the statutory duty. Okay, means RP or liquidator must verify and check all the means detail and documents to ensure that there was no wrong transaction happened which didn't defeat the creditor's interest. Okay, so means if in case if there is a negligency, so then RP will be responsible. That is their statutory duty to verify. If negligency is there, so then RP will be responsible. Now, what type of means transaction which we cover as per section 43, preferential, selective repayment to insiders, section 45, undervalued, sale before fair value, section 49, transaction to defraud creditors, asset stripping, section 50, extension credit, users loans. The landmark judgment related to this on avoidance transactions. Anuj Jain, IRP for JP Infratech and versus XML Limited. The Supreme Court judgment given mortgage is created to secure third party debt shortly before insolvency where preferential transactions are void. Okay. The judgment places a direct investigate burden on RP to look beyond form and examine economic substance. So these are the main duty of the IRP or RP when any assignment is undertaken. So then as a professional we must see and verify previous transactions to ensure that as per IBC code all the transactions are okay. In case if there is any preferential undervalued transaction to defraud creditors or extortion credit transactions are there, so then we have to take appropriate action as per IBC code. There is another case when Venus Recruiting Private Limited versus Union of India. The tribunal held RP must apply independent mind and cannot rely solely on management representation. Okay, means if any management representation is is given by the management. So we should not fully rely, because we also need to verify and check, because if someone is giving the detail and documents, okay, means we should not blindly rely on this detail and documents. We should also verify whether these details and documents are appropriate or not. Okay, there is a fundamental and wrong trading. Section 66 IBC says empowers the RP or liquidation to seek contribution from promoters' actions, personal liability for fundamental trading, penalties where business was conducted with the intent to defraud, landmark judgment under Section 66. Committee of Character Sar versus Tish Gupta says, so as per judgment given by the Supreme Court, clarified approval of a resolution plan doesn't extinguish liability for fundamental or wrongful trading. Means if any wrong things are done by the previous promoter, it doesn't mean resolution plan will they will not be liable for previous things, previous promoter, ex promoter, ex director for wrong thing, they will be responsible and liable. New resolution applicant and resolution plan submitted by new resolution applicant, they will not be liable for previous any activity, but ex promoter and director will be responsible if they have done with the wrong intention and they have done such type of above type of transaction, so they will be liable for any wrongful trading, any wrongful transaction as per the IBC code. Now there is another judgment given by the NCLT Mumbai versus IDBI Bank JP Infratech. The tribunal observed Section 66 proceedings are independent and can continue even after CIRP. Okay. See here, that transaction is fraudulent and wrongful trading. Who did this? The promoter and director did this thing. So means, for example, if there is a crime, so then ED can also take appropriate action, because these things done by the promoters or ex-promoter or ex-directors. Okay, so then they will be responsible for this thing. Now, cooperation with ED, SFIO, CBI and other agencies, what will be the role of the IRP, RP or liquidator in respect to the cooperation with ED, SFIU, CBI and other agency? For example, in case ED will definitely lease our corporate debtor assets, but if in any action, any crime, any thing done wrong by the ex-promoter director, so then definitely IRP, RP have, if any detailed document, then they need to share with the these agencies. Okay, IRP, and also as per they are also responsible and to the educating authority. If any educating authority give any direction, so they will have to work accordingly. IRP, RP liquidator must share financial record and forensic report with these agencies if they ask. Okay, and also permissible as per the IBC code. Okay, they will have to also to take respond to summons under PMLA, Companies Act and CRPC, facilitate access to books, assets and digital records. If they want any detailed documents, they need to cooperate with all the agencies. Okay, if they need documented detail, so they need to share the document detail as per the IBC code. Okay, in case if there is a confidential thing, maybe if any statutory requirement, they will have to share the detail and documents with that statutory authority. Judicial guidance on interagency cooperation, Directorate of Enforcement versus Axis Bank. The court observed insolvency professionals are obligated to cooperate with ED investigations, provided CRP objectives are not frustrated. If ED wants any detailed document, they will definitely, our resolution professional or IRP will have to cooperate with ED, because ED will also cooperate with the resolution professional, because if they have attached any asset, so they will release as per the IBC code. But in case if they want any further detailed document to ensure whether these transactions happened in right manner, wrong manner, and who was the culprit, means whether KMP, promoter, director, or any other specific person, so then resolution professional must cooperate with these agencies, but objective will be this CRP should not means frustrated, means there will not be any means if cooperation means it doesn't means ki they will give much time to ED ki they can take time to release the asset. Okay, means the objective of this code need to be fulfilled as per the time bound period, as per statutory means objectives. Okay, CRP objectives are not frustrated in keeping mind resolution professional need or must cooperate with the all the statutory agencies including ED, SFIO, CBI or any other agencies. If they need any detail and document, resolution professional must share that detailed document as per the statutory requirement. There is another landmark judgment case, Vijay Mandal Chaudhary versus Union of India. The Supreme Court upheld ED's authority to investigate money laundering even during CRP. Okay, so means they can proceed their investigation. Okay, they have the right as per this act. Okay, and they can take appropriate legal action, which we have already discussed. Okay, means ED authority to investigate money laundering if there is any money laundering, if there is any crime by any ex promoter, director or KMP, then section 14 moratorium will not protect to the culprit who did this type of crime under the PMLA or any other criminal activity. So then agency can continue to investigate during CRP also. Okay, but they will not hinder or create any problem for CRP process. CRP process must be continued within a time bound period. Practical coordination, agencies, nature of cooperation, ED proceeds of crime. Okay, so these are the practical coordination means they need to cooperate. Now protection available to insolvency professionals for bona fide actions. Legal safeguards. Provisional protection grants section 233 IBC immunity for good faith. There is a section 2082 standard of care and diligence, section 22 preservation of assets, section 240 protect against vexatious proceedings. There is a landmark judgment cases related to this. Judicial recognition of IP protection means Om Prakash Union of India Delhi High Court held insolvency professional acting bona fide cannot be subjected to criminal prosecution merely for performing statute. Means if they have done their statutory duties, if they have done their all the activities as per the IBC code, if they have done any negligence, okay, so then they will be responsible. But normally if they have done their work in normally, so they then means no action or legal action can be taken, because if they have done all the things in the right thing. State Bank of India versus Ramdev International, the terminal ruled RPs are not personally liable for business decisions taken in good faith. Okay, if business decisions taken in good faith during CRP, if decisions are not taken in good faith, then they will be liable. If decisions are taken in good faith, if that decision was not right or wrong, or that will not matter, but the intention was right. If decisions are taken in good faith during CRP, so then they are not means personally liable. But if with the wrong intention business decisions taken by the resolution professional, so then that resolution professional will be responsible. So that is very important point. Practical challenges and best practices. Common challenges: non-cooperation by ex-management. As a professional, we have to face, because they don't want to share the detailed document. They don't want cooperate, and we have to sometime approach to the authority. Then educating authority give the appropriate direction to the ex-management. So this is the practical means problem, or we have to face. Threat of personal litigation, parallel investigation by multiple agencies. So these are the common challenges. Best practice for IPs. Early forensic audit. If insolvency professional in primarily find there is need to do forensic audit, if there is this such of transactions are appearing, so then they should go for forensic audit to ensure that these transactions are as per IBC code or not. If not, then appropriate action can be taken as per the IBC code. Detailed documentation of decisions, regular reporting to COC and IBBI, written communication with investigating agencies. Conclusion: IRP, RP liquidity are central to fraud detection under IBC. Avoidance transactions under Section 666 proceedings are powerful tool. Cooperation with enforcement agencies is mandatory, not optional. Okay, means for statutory authority as per statutory requirement. If there is statutory requirement, if for example, if any direction by any adjudicating authority or any statutory authority, and it's means statutory, so then RP will have to means cooperate. It's mandatory, not optional. Okay. Now statutory and judicial protections exist for IPs acting bona fide with the good faith and with the right intention. They have the statutory and judicial protections. But if in case of negligency, no decision taken by the right or good faith, so then they will be liable. Effective fraud detection enhance credibility of CRP and confidence of creditors. Okay. If with right intention, okay, and good faith, if process is continue, so then it will definitely enhance the credibility of CRP and also give the confidence of creditors. And if creditors have the confidence, so then they will not approach to the adjudicating authority. Means otherwise what happens if they don't have the much confidence about the CRP process which is going on, which is running by the resolution professional, so then they will again and again approach to the adjudicating authority. So means lack of confidence also means create problem, and also means take very much time to resolve the resolution process. So it's very means important to means enhance or create confidence with characters. Now, fraud detection during CRP, red flags and indicators. Fraud detection during CRP, red flags and indicators. Concept of fraud under IBC during fraud during CRP is not confirmed to criminal intent alone. Under the IBC framework, fraud includes transactions structured to defeat characters. If something is done wrong to defeat the creditors, so then it will covered under the fraud. Artificial depletion of assets value, concealment of misrepresentation of financial position. So these are the means fraud, because with the wrong intention, if anything is done to make money, okay, or for any other purpose, so that is covered under the concept of fraud as per the IBC. Now Supreme Court says in the case of Swiss Ribbons versus Union of India, held that the code casts a duty of insolvency professional to identify and undo transactions that erode the value of the corporate debtor to detriment of creditors. For example, if the corporate assets have been transferred by the promoter or director in the taken in their custody, okay, so then what will happen? That is lost to the business. If they have taken that assets lower than the fair value or lower than the book value, fair value, so that what it means, that is also the means wrong thing, because that is also means defeating to the creditors. Okay, so means it will also impact on the business. Okay, if these transactions are there in the business, so then need to take action so that if with the help of the appropriate direction, the maximum valuation of the assets can be done by the resolution professional. Now, if there is a professional preferential undervalued extortion or a fraudulent transactions are there, so then selective repayment to promoters, directors or group companies shortly before insolvency. If they know key company, there are very much chance company may be or will or are going in the resolution insolvency, be someone have some means submit the petition. So if if continuous payments are done in the past to the promoter director group companies shortly before insolvency, that is the red flag. If similar transactions are coming, okay, and frequency of transaction are very much okay, similar amount of type of transactions are done, so these are the red flags and indicators ki something, there may be a something wrong. Okay, creation of security interest for old unsecured debts, discharge of third party liabilities of promoter group. So means, so these are the red flags and indicators ki there may be chance of something wrong. So then there is a landmark judgment related to this. Anuj Jain IRP for JP Infratech versus Axis Bank Limited. The Supreme Court ruled that mortgages created to secure loans of related entities were preferential. Okay, financial debt required direct dispersal to the corporate debtor. RP must look at economic substance, note Murray from. The judgment transformed the approach of RPs from accounting review to forensic scrutiny. If these are the type of transactions, if primarily if RP think these type of transactions are in the business, so they can go for a forensic audit. Okay, means if there is a preferential transaction, okay, so then they, if they think that they can go for a forensic means scrutiny. If there is an undervalued transaction, section 40 and 49 IBC, how we can means find if there is an indicator. If we find there is an indicator and red flag is there, means sale of land, plant, means if they sold the assets below than the cost, fair value, market value. Okay.
Hello.
Yes.
Hello. Haji Sajeev ji. Namaskar sir.
Someone is unmute. I will request you to mute.
जी.
There is a sale of land, plant or trademark at price significantly below market value. So these are the red flags and indicators. Transfer of assets to promoter controlled entities without independent valuation. Okay. For example, if promoter or is selling the assets in the control and entities, so then if they have done the valuation, then it's okay. If there is a transfer at the fair value, that's okay. Okay. If there is a board valuation and if means so then it's okay. Otherwise, if sale of the land and plant and machinery below fair market value is happened, so then it means that is the red flag and indicators. Write off of receivable without recovery effort. Okay, means we have sold the material to one party. Okay, but we have not done any effort. Means, for example, if I am to get the money, if I am not getting the money, definitely I will go for a legal action. I will send legal notice. Means I will do something. If without effort, if I am means writing off that receivables, so these are the red flags and indicator. Means these are the transactions called the undervalued, because if sale of the land was the 550 crore, if we have sold at 20 crore, okay, so as the RP, I will check. I would like to know what is the present value of the asset and what was the value of that asset, fair value. If I found these type of undervalued transactions, so then we need to take action as per the IBC code 2016. These type of transactions also indicate, and these are the red flags. Landmark judgment related to this: Bimal and Desai versus Gujarat Industrial Development Corporation. Judgment given by the enclave, the tribunal held that the transaction at gross undervalue during the look back period create a presumption of intent to defraud creditors. I mean, with the intention of defraud creditors, if these type of transactions happened, so these are the means undervalued transactions. And some indicators we can find, some red flags we can find. Okay, so then when we use means these type of means red flags, then we can take means and take means appropriate action. Another is exponential characterization, section 50 IBC, red flag indicator. If there is a loan at exponential interest rate for above market norms, okay, so then what happens? Short-term loans secured by high-value assets, financing from connected parties with panel terms. So these are the red flags. Okay, if these are the transactions happened, so means So these are the red flags and indicators. And we can find these type of transaction means easily. If we are unable to find, but there are multiple transaction and we are to need to dig out, so then we can also have forensic auditor. Landmark judgment is SBI versus Veterinary Limited Enclate observed financing structure to extract unreasonable advantage from a distressed borrower is extortionate and voidable. Another is fundamental transaction, section 66 IBC, red flag and indicators. What will be red flag and indicator in this situation? Continuation of business despite clear insolvency, incurring liabilities with no reasonable prospect of repayment, falsification of books and surplus of defaults. These are the means transactions with the wrong intention. So these are the fundamental transaction. The purpose of these transactions to defraud the creditors. The landmark judgment case related to this, Committee of Creditors of Isar Steel Limited versus Tish Kumar Gupta. The Supreme Court clarified approval of a resolution plan doesn't absolute promoters or directly from liability for fundamental or wrong things. Okay, so this thing we have above also we have discussed. If the resolution plan approved, it doesn't means the earlier promoter or director can escape from their liability or claim for any fundamental or wrongful trading. Okay, if they have done any transaction in normal manner, there is no problem. But if with the intention of wrongful trading, with the intention of fundamental, so then ex promoter, director or KMP will be responsible, and appropriate legal action will be taken and will continue by the appropriate agencies. Another is financing and diversification of funds. Means sometimes what happen, ki company are transfer funds from one company to another group company. So if these are the type of things, so these are also a red flag. Round tripping means loan given to one company, then B company given loan to the another company, C. And so these are the, if these are the transactions are there, so means they are diversifying of the funds. So that is also maybe with the wrong intention, rounding tripping through group companies. So then what happens when, as you know, key group, there are a videocon company. Okay, so there were multiple transactions. So then in that case, not single company goes went in the CIRP or liquidation process. All the group companies went into the liquidation or CIRP process. So that means if these are the transactions happened, A company given to B, B to C, C to D, D to A, B, C. So if round tripping, if misappropriation of funds are there, means these are the transactions are also red flag. And if you found as a common partner, so then we need to check and verify very carefully advances to promoters without business justification. That is also a means a red flag. Inflation of expenses and fictitious vendors means if we are means promoter, director, or any KMP or any stakeholders submit their means forged bills for expenses claimed for expenses. Okay, and if there's a fictitious vendors means vendor is not there, but we have shown as a vendor and we are also making payment because with the intention of misappropriation of funds. So these are the red flags, common patterns. If you find, so these are the red flags and indicators. Red flags: large loans and advances without repayment schedule, suddenly spike in related party receivables, fund transfer immediately after bank disbursement. So in this pattern, we can means have an idea there may be chances of something wrong, and these are the red flags and indicators which gives us idea कि there may be something wrong and we need to further need to check and verify these type of transactions. There is a landmark judgment case in this Punjab National Bank versus Nirav Modi. The court recognized layered division of bank funds through overseas entities constitutes fraud and money laundering. Another case was DHFL case. NCLT Mumbai forensic audit revealed systematic financing of funds through promoter controlled shell entities. Means sometimes what happens if there is a promoter or director in a big company, so they slowly they transfer their funds to another entities. Okay, in such a way to misuse of their funds, means they transfer their fund in shell companies. Okay, the intention is wrong. Okay, so these are the things which also need to check and verify. Led to proceeding under IBC, PMLA, and Companies Act simultaneously. Okay, there is another point. Benami arrangement and layer transactions means sometimes what happens, person don't buy or have an asset in their own name. So that these type of transactions are called Benami arrangement, because these are transactions also happen done for the wrong intention. Because for example, if there is any leader who will not take the any means money or any land or any asset name, they will take in the name of their relative. So these are the things are also a red flag. Nature of Benami and layering assets held in the name of relatives, employees, or front companies. Multiple layer of transactions to discuss beneficial ownership, because here main owner is to hide. Okay, that owner don't want to come into the picture. Okay, so these type of transactions are called Benami arrangements. How do we means find out what will be the indicator, what will be the red flag? Properties used by corporate debtor but owned by third party. Sudden asset acquisition by relative of promoters. Complex intercompany fund movements without commercial rationale. So these are the red flags. If these are the activities, if we found, so then it means these are the red flags and indicators which give us the idea there may be chance of something wrong. So then if we will go into the depth, so then we can find out whether this thing right or wrong. But if we are unable and we don't have so much time, so then we need to hire forensic auditor, which really helps you give you the clear report and clear picture कि these transactions are means okay or not okay as per the IBC code. So then the landmark judgment cases related to this: Benami India Industries Limited versus Bank of Baroda. The tribunal emphasized resolution must consider true ownership and beneficial interest, not merely legal title. Okay. There was another judgment case of Vijay Mandal Chaudhary, Union of India. The Supreme Court held attached of layered and Benami assets proceeds of crime under PMLA even during CIRP. Okay, now what are the related parties, actions, and shell entities? If any payment to entities with common director or shareholder, multiple companies operating the same address. Okay, see, if multiple companies using the same address is not an issue, but if transaction happening and between these countries, but you can have an idea. For example, if multiple companies are at one place and transactions are there, so you can have an idea there may be something wrong. Okay, no genuine business operations or employee. Okay, for example, if employees are not there and we are making payment, okay, because we have shown persons as employee. Okay, no genuine business operations are there. So these are the common indicators. Red flag indicator practical events, common email domain. Okay, centralized control, circular and fund flow, artificial turnover, no GST employee data, shell entity, high related party sales, profit shifting. So these are the means common or red flag. Okay, for example, if we are using common email ID and for there are 7 to 8 entities. Okay, so then what it means they have the interrelated companies. If you are transferring the funds from one to another company, so there may be maybe chance of something wrong. Okay, so then we need to more focus on these type of transactions to ensure these transactions are happened means as a normal transaction or with the intention of defraud. So these are the red flags and indicators which gives us an idea we need to further verify, check or not. The landmark judgment Phoenix ARC Private Limited versus Paid Financial Services Limited 2021, the Supreme Court held related party transactions designed to gain control of CRP or influence COC decisions must be strictly scrutinized. As Mittal, India Private Limited versus Tish Kumar Gupta. The court ruled controlled and beneficial ownership matter more than formal shareholding. Okay, see, integrated red flags matrix means preferential insider payments, section 43 attacks for undervalued, section 40 below market sale. If you are doing before market, that means we have sold the asset undervalued. If we found these type of transactions, so then we need to take action as per IBC code. If there is a preferential transaction, okay, so then section 43 attacks, extortion assets, useless loans, section 50 fundamental trading, insolvent, so then section 63. So these are the integrated red flags matrix for CIRP. Now, conclusion. Fraud during CIRP is systematic, layered, and intentional. That is not unintentional. That is not unsystematically, because any fraud, if is done by the any data management or any other person, so that will be systematic. Okay, and with the wrong intention. Insolvency professional must act as a financial investigator, not just administrators. Landmark judgments mandate substance over from beneficial ownership over legal title and accountability over settlement. Early identification of red flags is crucial for maximization of value of assets, protection of capital, shielding resolution applicant from future liability. Process of reporting fraud under IBC. When we have already find that there is something wrong and fraud has been done by the promoter, director, or any other person, so then what will be the process of reporting fraud under IBC code? Legal obligation to report fraud under IBC. Fraud reporting under IBC is not a discretionary. Okay. Someone is unmute. I will request you to mute. The IRP RP liquidator has a statutory duty to report suspected or established fraud. Means here it's clearly defined. Fraud reporting under IBC is not a discretion. It doesn't mean that I am to take decision. If I am an insolvency professional liquidator, it doesn't mean that it depends on me. If I found that there is something wrong, okay, there's a transaction is showing fraud. So then I will think I should report or not. No, that is mandatory. I will have to report. The IRP, RPL liquidator has statutory duty to report suspected or established fraud. If there is a suspected transaction, then we need to verify. Okay, the Supreme Court in Swiss Ribbons Private Limited versus Union of India emphasized that detection and reporting. There are two things: detection and reporting of fundamental conduct is central to the effectiveness of the insolvency framework. Reporting fraud to the adjudicating authorities, because insolvency professional or liquidator is reporting to the adjudicating authority. If these type of transaction fraud is there, so then as a resolution professional liquidator, we will have to report to the adjudicating authority. Okay, so what are the statutory base? Section 25(2)(j), RP must file applications for avoidance of transaction. Section 40 through 51, profession undervalue social transactions, secretary fundamental under roving. Section 65, residual justification of NCLT. Section 35(1), liquidator to investigate and report fraud. Procedure step before NCLT. Process flow, identification of red flags. Okay, if there is a red flag we found, we will appoint appointing of forensic auditor if required. Examination of look back period transactions. Preparation of investigation report. Filing of application before NCLT. Okay, for example, if there is an undervalued transaction, so then what will happen? We will report to the NCLT, then that assets will be recovered from that person, or that and difference will be recovered from that person with the penalty. Means appropriate legal action will be taken by against that person. Filing of application before NCLT, seeking appropriate relief. So this will be the second step by the resolution professional liquidator. Relief that may be sought by the adjudicating authority. Declaration of transaction as void. That transaction will be, for example, if I have sold that asset at undervalued. Okay, so what will happen? So that transaction will be void and that asset will be recovered. So means that will be the relief by the adjudicating authority. Declaration of transaction as a void. Recovery or contribution order against promoters or directors. Direction for investigation by SFIO or CBI. Permission to share record with ED. So these type of relief will can get from the adjudicating authority. Okay, so this is the when as a resolution professional I will report to the authority. Okay, if in reality that transaction was undervalued or fundamental, so then appropriate direction will be given by the adjudicating authority. So these transactions will be deemed as a void. So means that will be the relief. Okay. Now, now the related judgment to this issue. Anuj Jain, IRP for JP Infotech versus Axis Bank Limited. The Supreme Court held RP is duty bound to examine past transactions. Okay, that is the duty of the RP to examine past transactions and move the NCLT for appropriate relief where transactions are preferential or fundamental. So that is very, very important. Okay. See, that is the RP duty bound to examine past transactions. That is their duty and move the NCLT. Means RP cannot decide ki whether if he found these type of transactions, so he cannot decide ki I should go or no. That is their duty. If these type of transactions are there, then RP will have to move to the NCLT for appropriate relief, and adjudicating authority will give the appropriate direction in case if there is a these type of transaction happen, so these type of transaction will be void and relief will be given by the adjudicating authority. Now IDBI Bank versus JP Infotech, what they say is NCLT observed non-filing of avoidance applications despite availability of a material amount to failure of the statutory duty. Okay, so that will be against the resolution professional. Okay, now intimation to IBBA and other regulatory authorities, statutory and regulatory framework, section 2082D, IP to report misconduct, IBBI, Insolvency Special Regulation, mandatory disclosure of fraud, section 35(1) liquidator to report to IBBI. Okay, authorities to be informed, IBBI, RBI, SFA, SAB, MCA. Nature of intimation, if IBA fraud details, forensic report to IBBI, RBI bank fraud is there, so then RBI, SFA corporate fund, SAB listed company fraud, MCA violation of Companies Act. So there is a landmark judgment cases, Om Prakash versus Union of India, Delhi High Court. The court held timely reporting of fraud to IBBI. Okay. Okay. Timely reporting of fraud to IBBI shields insolvency professionals for allegations of suppression or complicity. Okay, now there is another coordination with enforcement director under PMLA. So this in shortcut we will review and discuss. When ED involvement is triggered, fraud involves proceeds of crime, layered fund diversion, Benami or shell company transactions are there, bank fraud as schedule offense. So then RP will coordinate with the enforcement director under PMLA. Role of IRP, RP regulator versus ED provides books of accounts, bank statements, forensic reports, respond to summons under section 50 of PMLA, identify assets linked to proceeds of crime, assist in valuation of attached assets. So that coordination will be from RP side, IRP side or liquidator side. If PMLA activity is also going on, there is judicial guidance, director of enforcement versus Axis Bank, Delhi High Court. The court held insolvency proceedings and PMLA investigations may run concurrently. Cooperation by RP is mandatory. Okay, means as we have already discussed, if PMLA investigations are in the process, so PM as per ED can also do investigation against promoters director, ex-promoter director and KMP. Okay, with CIRP process. Okay, and RP will have to cooperate with, it's a mandatory, it's not a optional. Okay, so that is very, very important. Means PMA and CRP can also go both simultaneously, but for corporate debtors, PMLA will have to raise the asset. PMLA will not hinder the CRP process, but as well as if there is a crime happened, so then legal proceeding or the proceeding or investigation they can continue against the culprit persons. Vijay Mandal Chaudhary versus Union of India. The Supreme Court is clarified attachment under PMLA is independent of insolvency proceedings. Means it is nothing to do with the means insolvency proceedings. Both are separate things. Okay, attachment and PMLA is independent of insolvency proceedings, so both are different thing. But when CIRP will start, moratorium under Section 14 will start, so then then IBC will override the PMLA, and then PMLA will not can be hinder the CIRP process. Impact of fraud reporting on resolution liquidation timelines. CIRP timelines. CIRP period under Section 12 remains unchanged because that is a time bound period. Avoidance application can continue beyond CRP period. Okay. Resolution plan approves doesn't bar fraud proceedings. Okay, that will not the impact on the CRP timelines. Judicial position. Committee of Creditors of SR Limited versus Tish Gupta. The landmark cases says judgment given by the Supreme Court. Fraud investigation doesn't derail CRP timelines. Both process must coexist. Okay, means if there is a fraud investigation is done by the authorities, so they can do, because in this situation what is happening, they are doing the fraud investigation against the ex corporate means ex director promoters. Okay, so means that does not derail CRP timelines. Okay, they can do simultaneously, there is no problem. Means if CRP is in the process, it doesn't means कि ex promoter director will also protect as per Section 14 moratorium. Okay. Now, JSW Steel Limited, Mahindra Kumar Khandelwal Bhushan power case. The court observed resolution doesn't grant immunity from investigations from prior fraud. This thing we have already discussed. Means resolution doesn't grant immunity from investigation for prior fraud. Means resolution plan is approved. It doesn't mean if some other in case if fraud happened, okay, before CRP will not means they cannot escape ex promoter and director. Now, what will happen in liquidation phase? Fraud recovery continues under Section 35 and 66. Okay, proceeds recovered from part of liquidation estate unless confiscation under PMLA. Liquidation timeline may extend for recovery proceedings. What are the practical challenges and best practice? Challenges parallel proceedings. That is the challenge. Asset attachment under PMLA. Okay. Parallel proceedings, assets attachment under PMLA, delay in forensic audits, resistance of ex management. So these are the practical challenges we have to face, because if parallel proceedings will be there, so then I will, as a resolution professional, we will have to cooperate that agency. It will also take time, and the focus will be on two part, because our first focus will be, I will also my first priority will be to complete the CRP process, means in the time bound period, but I will also support to the means statutory authority. So means my focus will be in two parts. If asset attachment is there, it may also take time to release the asset by the PMLA, by ED. Okay, so it will also means sometimes it may also take time. Then it also impact on the my time bound period. Delay in forensic audit. If there are so much type of transactions are there, so it may take some time to do the forensic audit. Okay, so resistance for ex management, non-cooperation for ex management. So these are the practical challenges we have to face as a professional, insolvency professional. Best practice for IPs: early identification and documentation, clear segregation of tainted assets, regular reporting to COC and IBBI, written coordination with ED and SFIU, seeking NCLT directions for IT. Wherever we don't have any clarity, and if don't have clarity means also note specifics if section is there. So then what will happen? We can go and approach to the NCLT for clarity. And for example, if any statutory authority is coming, okay, and if we need the clarity, so then we can also, in case if we need the clarity, we can also approach to the NCLT, because ultimately we are, as a licensed professional, we are facilitator, we are also reporting to the, we are a legal officer, we are reporting to the adjudicating authority. Conclusion: reporting fraud under IBC is mandatory, structured, and multi-agency. NCLT remains the primary form for insolvency-related fraud remedies. IBBI reporting ensures regulatory transparency and IP protection. ED coordination addresses criminal laundering of proceeds. Fraud reporting does not stall CIRP but strengthen resolution integrity. Okay, now we will discuss what type of practical challenges and criticism of fraud detection during CIRP. Okay, practical challenge. Fraud detection during CIRP, while crucial for credit protection, face multiple operational, legal, procedural challenges. Understanding these challenges is essential for insolvency professionals to mitigate risk and navigate complex regulatory framework. Parallel proceeding and conflict order. This is the first main challenge we have already discussed. Okay, when another agency is also doing any simultaneously investigation. So this is the challenge for resolution professional. Okay, because if CRP under IBC operates similarly with criminal investigations under PMLA, investigation under Companies Act, SFIO, bank fraud investigation, CBI, RBI, multiple authorities may issue conflict directions, creating uncertainty in management or corporate data assets. So these are the type of practical challenge we have to face as an insolvency professional. Okay, practical implication: RP may face difficulty in executing resolution. If assets are attached by ED under PMLA, COC decision may be challenged in multiple forms, increase compliance burden and litigation costs. Okay, landmark judgment, Director of Enforcement versus Axis Bank, insolvency proceeding under PMLA investigation can run concurrently, means both can be done. IPs must cooperate, but NCLT retains power to resolve conflicts. Means Committee of Creditors of ISRMT versus Tish Kumar Gupta. Supreme Court held fraud investigation doesn't stay CIRP, but process coexists, but orders must not frustrate resolution objective. Means investigation can be done by another agencies, but CIRP must not derail. That CIRP must be completed with the objective in time frame period. Delay due to assets attachment. Nature of ED may attach assets under PMLA during CIRP to prevent disposition of proceedings of crime. Attachment can delay. Practical implications. There is a landmark case. Supreme Court observed ED attachment is independent of insolvency process. CIRP can continue, but assets release depends on the education under PMLA. What will be the impact on valuation? Means if PMLA will attach the asset, if it will take time, so then it will impact on the value maximization. Nature of the challenge: PMLA and other regulatory attachment may reduce the pool of available assets, impacting releasable sale value, investors' confidence, feasibility of resolution plans. Practical implications: risk of lower bids due to uncertainty of assets ownership. COC may need to adjust resolution expectations, balancing risk and recovery. Related judgment: IDBI Bank versus JP. Tribunal observed assets under attachment may be excluded from resolution plan, but RP should facilitate ED investigation to prevent forfeiture of recovery value. Another point is lack of clarity on release of attached assets. Nature of challenge: ED or other authority may attach assets provisionally, and these requires education by ED under PMLA, NCLT, and approval in context of CRP, no explicit statutory timelines for coordinated these release. So these are the practical challenge as we have to face. Now, practical implication, IP may face litigation or obstruction in executing resolution plan, risk of claims by resolution applicant or COC if assets cannot be transferred. Landmark judgment was in the case of Punjab National Bank versus Nirav Modi. Attachment of assets may persist for long period. Insolvency professionals should maintain documentation and coordinate with enforcement agencies to mitigate risk. What is the risk exposure of insolvency professional? Nature of the IPs may be held liable if fraud is not detected or reported in time. COCs mislead actions are alleged to be negligent or malevolent. So this is the risk involved with the for insolvency professional, because if we have not done this activity with means if we have done negligence, then we will be liable. Okay. Practical implication, personal liability under section 208 66 to 40 IBC if bona fide conduct is not demonstrable, reputation risk or professional scrutiny by IBBI. Now, protection measures, basis bona fide action immunity, section 233 IBC, documentation of decisions. If we have documentations, IBB IP 2016, disclosure to COC IBBI, section 2082D, circulars, cooperation with EDSFI, section 3511, section 60. These are the protection measures. Landmark cases, IP acting in Oberkash case, IP acting in good faith and in accordance with the statutory duties are protected for criminal and civil liability. Means if we have done all the act in good faith and in accordance with the statutory duties, means as per IBC code and are protected. Means if I have not done act as per good faith and not done act in as per statutory duties, so then I am liable for my negligence for civil or any criminal case, because I have not done my duty as per the statutory duty. The State Bank of India versus Ramdev International Limited tribunal ruled RPs are not personally liable for business judgment taken in good faith, even if some transactions are later found fraudulent. Means if I have done with my with my full knowledge and my experience, okay, and with the professionalism, okay, and in good faith, okay, I mean I have done at my best, okay, then I'm not personally liable. Okay, if I miss any transactions, if I couldn't find any transaction, that transaction was fraud, but I couldn't catch. So it doesn't mean ki I will be personal liable, because if I have taken all the appropriate steps, okay, if I have done as per the statutory, I perform my all the statutory duties. I have adopted all the normal process, okay, which is required as per the IBC code, then I will not be liable. Okay. Now, summary practical challenges, parallel proceeding, impact on CRP, judicial or regulatory guidance. Parallel proceeding means conflicting orders, yeah, litigation. So means if parallel proceeding, then if there is a means conflicting orders, may any judgment or any direction given by another authority also create hurdle and problem to the resolution professional. Asset attachment delays, timelines, and cash flow impact. The landmark judgment cases are given there. Impact on value maximization, reduced realizable value, lack of clarity on release, execution of resolution plan, risk exposure for IPs, personal and professional liability. So these are the also the practical challenges we have to face. Conclusion and recommendations. Fraud detection during CRP is critical but operationally complex. IPs must balance statutory duties, asset preservation, and coordination with enforcement agencies. Documentation, timely reporting, and cooperation are essential to reduce litigation risk. Okay, courts have recognized the need for current proceedings and protection exists for bona fide actions by IPs. Awareness of judicial guidance ensures value maximization and credibility of CIRP. Okay, now we will discuss the landmark judgment cases. In above, we have also discussed in short so many landmark judgment cases, but few cases we for the means we will review. These are the critical and landmark judgment cases which really help us when we are dealing with PMLA and IBC simultaneously both. So then these landmark judgment really help us how to deal these situation. Okay, now supremacy and coexistence of PMLA and IBC, nature of conflict. IBC focus on corporate insolvency process, asset maximization, and capital recovery, as we have discussed in previous sheets. PMLA focus on prevention of money laundering, attachment of proceeds of crime, and criminal prosecution. When assets of a corporate debtor are under attachment by ED, questions arise: can CIRP proceed? Are resolution applicant entitled to these assets? Which law prevails when conflicting claim arise? So these are the nature of conflict. Now coming to the landmark judgment cases, if these type of issues comes, then how we can deal? Landmark Supreme Court judgment, Swiss Ribbons, Private Limited vs. Union of India, validated IBC framework and objective, held that resolution professional must examine fundamental transactions. While primarily about IBC validity, it laid groundwork for interaction with other statutes, emphasizing that CRP objective cannot be frustrated by procedural delays. Okay, so that is the landmark case, means IBC code will have the override effect and primacy over all the other acts. Okay. There is another landmark case, Vijay Mandal Chaudhary versus Union of India. Supreme Court held PMLA is a special statute and attachment of assets under PMLA proceeds independent of insolvency resolution. Emphasized coexistence. CRP may continue even if ED attached assets, but resolution applicant cannot assume ownership of attached assets until clearance. Clarified that attached assets are not automatically transferred to successful resolution applicants. Another one is Committee of Characters of ISAR Limited with Sishwar Gupta. While approving resolution plan, Supreme Court clarified fundamental conduct or money laundering allegations don't bar CRP, but resolution applicants must not gain advantage for tainted assets. Courts uphold coexistence principle, IBC resolution and PML attachment run in parallel. Okay, this thing we have already discussed. NCLT guidance, IDBI Bank versus JP Infratech. Assets under PML attachment can remain excluded from resolution plan. Okay, until clearance, RP must coordinate with the ED. Resolution applicant cannot claim rights over attached proceeds. Highlighted the RP duty to maintain transparency and documentation. Okay, another case is Directorate of Enforcement versus Axis Bank 2019 Delhi High Court confirmed that CRP and PMLA proceeding can run concurrently. Resolution professionals must cooperate, but NCLT retains supervisory power to protect CRP objectives. Okay, now the treatment of attached assets during CRP. Legal position. ED attachment is provisional but enforceable. Resolution applicant plans IBC cannot include attached assets unless ED release them. IBC Section 40 moratorium doesn't bar criminal attached proceedings. Okay, now coming to the practical implications. RP should prepare separate assets ledger distinguishing tainted attached assets. Resolution applicants must be informed of assets outside CRP scope. Any attempt to claim attached assets may result in litigation or penalties. Right of successful resolution applicant. Supreme Court says right flow only for assets transferred under the approved resolution plan. NCLT position in JAPI Infratech case, resolution applicant cannot claim ownership over attached assets. RP must maintain full disclosure to COC and applicants regarding asset status. Okay, practical guidance. Resolution applicant must factor legal risk and attachment status into bid price. COC decision must account for ED and SFF pending investigation. The evolving judicial trends, coexistence principles we have discussed, protection of resolution applicant and IPs we have discussed, asset segregation and transparency we have discussed, substance over form in fraud detection we have already discussed. Okay. This is summary. Okay, summary means table, landmark, case, court, key principle, practical takeaway. These are the cases. These are the court. IBC validity. Foundation of RP as a fraud investigator. CRP can continue assets under ED, no transferable. Fraud allegation don't bar CRP. RP must exclude ED attached assets from resolution plan. RP operation cooperation mandatory. Okay, means RP will have to cooperate. That is mandatory. That is not optional. NCLT will have the supervisory power. Okay, resolution applicant cannot claim tainted assets. Okay. Now there is a conclusion. IBC and PMLA coexist. One statute does not nullify the other. Attached assets remain outside CRP until ED clearance. Right of resolution applicants are limited to free assets under approved resolution plan. Courts are trending towards protecting bona fide IPs, emphasizing full disclosure, segregation, and transparency. Okay. Now, impact on resolution applicants and stakeholders under PMLA means fraud detection and PMLA attachment during CRP have direct consequences for resolution applicant, creditors, and other stakeholders. Understanding these impacts is critical for risk management due diligence strategy formulation. Means if I'm a resolution applicant, if I want to submit resolution plan, so naturally if I need to check means at my end ki my resolution plan will be viable or not. I should go to submit the resolution plan or not. So I will definitely first I would like to go for due diligence because I would like to ensure कि whatever is means discussing whatever is showing in the detail or documents, whether this is true or not, means reflecting the true picture or not. So means as a resolution applicant, I will go for due diligence requirement. Okay. Nature of due diligence I will see. Resolution applicant must investigate corporate debtors' financial position, ongoing litigation, regulatory investigation. So I will go for a due diligence. The practical implications, failure to conduct proper due diligence may expose RAs to litigation by creditors or regulators, financial risk if assets are later attached, challenges in implementing resolution plans. Means as a resolution applicant, I would like to assets are not there. If asset is attached assets, if assets are not actually physically present, so these are the things which is really practical challenges create. As a resolution applicant, before submitting resolution plan, I will definitely go for due diligence to ensure the to see whether the two picture or fair picture is there or not, assets are there or not. Okay, and there is a challenge for resolution professional if books are not updated. Number one, number two, physically assets are not there. Number three, there may be chance of means there are some assets attached by the ED. So these are the practical challenges which every stakeholder want to know so that resolution applicants can submit their resolution plan and another side resolution professional can show the actual or clear picture to the resolution applicant and to the COC. There is a landmark judgment cases. With the help of landmark judgment we will understand. Resolution applicant must exercise commercial prudence including reviewing regulatory and enforcement proceedings before submitting a bid. RA cannot assume attached assets will be available. Proper due diligence regarding asset status is mandatory. Okay. So these are the risk of retrospective attachment. PML or the regulatory agencies can attach assets even after resolution plan approval if they constitute proceeds of crime. Creates retrospective risk for RAs who may have paid consideration for assets later deemed tainted. Practical implications: RAs may lose ownership of assets. There is a landmark judgment. ED retains independent powers. Resolution applicants must accept the risk of attached assets. Okay. Clean state principle we have already discussed. IBC aim to give a resolution applicant a clean state. Once a resolution plan is approved, resolution applicants are protected from past debt and liabilities of the corporate debtor as per Section 31 IBC. This thing we have already discussed. Key new resolution applicant, promoter, director, and means these will have the clean state status and will not be liable for any past claim and liability. Okay. There is also a conflict. PMLA attachment may override clean state protection if acquired through resolution or tainted process of crime. We will understand with the help of judgment. Clean state principle applies to operational financial character but doesn't confer immunity from criminal or enforcement proceedings. Now coming to the commercial and legal applications. Okay. See, in above, if you will see, practical application, RA must structure bids excluding attached or suspect assets. Okay. So RA can only do this thing. Now coming to the commercial and legal implications. Commercial risk, valuation adjustment, financing constraints, investors' confidence. Legal risk is also the potential claim by ED, COC or creditor if resolution plan includes assets later attached. So this is the legal risk. Landmark judgment, resolution applicant must factor legal risk into commercial valuation. RP must ensure COC awareness of the assets attachment. So these are the landmark judgment cases. Now we'll cover the conclusion. RAs are stakeholder must incorporate legal, regulatory and commercial risk assessment into CIRP participation. Proper forensic due diligence, asset segregation and disclosure are key to mitigating risk. Courts have consistently emphasized coexistence of IBC and PMLA, requiring RAs to balance commercial interests with statutory compliance. Now, we will discuss or go through the FAQs. Can ED continue attachment during moratorium under IBC? IBC moratorium means Section 49 starts prevention, enforcement of claims, recovery proceedings of transfer of assets, creditors during CRP. Objective, protect corporate debtor and allow orderly resolutions. PMLA means Section 5 and 8 applicable. Means ED can provisionally attach the assets. PMLA is special status. Practical implications. RPs cannot include ED attached assets in a resolution plan. Okay. So it means COC and RA must factor the known availability of attached assets in valuation. So these are the practical implications. Landmark judgment cases in regarding to that Vijay Mandal Chaudhary, Union of India, ED can attach assets even during moratorium. CRP continues but attached assets remain outside of RA control. Another case, moratorium under IBC doesn't prevent enforcement of PMLA. Attachment, concurrent proceedings are permissible. Now, another question is, are IP person liable under PMLA? This thing we have already discussed. If done and taken decision in good faith and performed all the statutory duties, so then not personally liable. But if done with wrong intention and not perform their statutory duties, and not submitted report with the wrong intention, so then IP will be personally responsible. IPs are statutory officers under IBC, not criminal investigator. Liabilities arise only if there is a mala-fide or negligent action, such as concealing fraud, intentionally, intentionally if these things have done. So then everyone will be, who is performing their duty, will be liable. Concealing fraud intentionally, misreporting financial or asset status, assisting in disposal of proceeds of crime. So if these things are done by the insolvency professional, or negligency action is there, mala-fide intention is there, so then IP will be personally liable for Act. Statutory protections, Section 230 IBC, immunity for good faith actions. If actions taken with good faith, the immunity is duty to report misconduct to IBAB regulations, protection for RPs who act bona fide. Practically, guidance IP must document all decisions regarding investigation and reporting. Cooperation with ED, SFIO, or CBI should be formalized in writing. Okay. The landmark judgment is IP is acting in good faith under IBC are sheltered from criminal or civil liability, means acting in good faith and performing the statutory duties as per the act. Then they have the means immunity. No action will be taken, but if with wrong intention and due to negligence, so then they will be liable and appropriate legal action can be taken. State Bank of India versus Ramdev International Limited Annulate. RP is not liable for business or financial judgments if taken in good faith, even when fraud is later detected. This we have also already discussed. If performed their duty and done all the activity in a proper process, if he missed to means to find out the fraud, something happened in the past, so he will not be liable if he has done and act in good faith and taken all the means appropriate actions, all as done all the as per normal process, so then he will not be liable. Okay, now third is what happens to attached assets post resolution. Resolution plan approved under Section 31. Transfer only assets included in the plan. ED attached assets remain under statutory control until release. ED release assets after due investigation. RA may acquire rights per resolution plan. PMLA configuration assets are excluding from CIRP assets. RAs cannot claim compensation unless protected under indemnity clause. Okay. RAs must segregation free assets from attached or tainted assets. Consider extra or concessional transfer clause to mitigate risk. The land attached assets remain outside RA's control until ED release them. Resolution applicant cannot claim ownership of assets under attachment. RP must maintain clear segregation. Can fraud derail CRP or resolution plan? CRP objective value maximization. Okay. And fraud detection doesn't automatically detail CRP but may influence inclusion exclusion of asset resolution plan, right of promoter writers, bidding and valuation by RAs. Okay. RP must file avoidance of or section 66 application before NCLT for preferential fundamental transactions. COC must be informed. Resolution plan may need adjustment based on forensic findings. Landmark case in Anuj Jain, RP must investigate preferential fundamental action. Fraud detection is integral, not optional. Okay, that is integral. RP will have to report. If he no not report, then he will be liable for this act, and legal action can be taken as per the IBC code. That is not the optional. He cannot take decision key whether I should report or not. It's mandatory to report if there is a fraudulent action is there and he found. If he doesn't found act in good faith, no problem. But if acted in good faith means found or not reported, then he will be responsible. Committee of creditors. Okay, fraud doesn't bar CRP or resolution plan, but RAs must not gain advantage from fundamental or tainted transactions. Okay, there's another last one FAQ. How should RA stakeholder mitigate the risk for PML proceeding? With the help of due diligence, asset segregates, asset maybe segregate contractual safeguards, disclosure, ensure full disclosure to COC lenders regarding PML proceeding, documentation, all quotation with ED. So in these means RA and stakeholder mitigate the risk. If a resolution applicant will go and do the due diligence, okay. If asset segregation is there, which assets are available, which are not available, which are in the attached assets. Contractual safeguards include indemnity clause for tainted or respect attached assets, especially excluded ED attached from bid valuation. So these measures can be adopted by the RA. These are the landmark judgment cases. SR, Steel, Supreme Court transparency and disclosure is essential. Coexistence principle requires planning around attached assets. Means both activity can be done simultaneously. Okay. Now, if someone have any query, question, you can ask. Otherwise, we can conclude this session. If you don't have any query, question, we can conclude the session. Can we conclude the session if we don't have any query, question? Hello, Anjali, are you there?
Shall we conclude, sir?
Yes, we can conclude. Thank you.
Okay, thank you very much, sir,
Thank
for
you.
such a knowledgeable session.
Thank you,
Sir,
sir.
please share the PPT of the session.
Sure.
Thank you very much, sir.
Thank you.
Thank you, sir. Thank you very much.
Thank you.
Thank you, sir. Thank you.
Thank you.
Thank you, sir.